Hearing the Navigators Insurance Company appeal.
My Lords. My Lords, in this matter I appeal.
Oh, how do you put this seat has got pushed forwards? How do you get it go backwards? What, yeah, just tip it backwards a little bit.
This side.
Okay. Yes, that's better. Right.
Thank you. My Lords, good morning. In this matter, I appear with Mr. MacDonald on behalf of the owners of the The Atlantic. My only friends, Mr. Edelman and Mr. Blackwood, appear for the war risk insurers.
Yeah.
And your Lordships will have seen how this appeal arises. It concerns issues of construction and causation in relation to the interplay between the insured peril and the exclusion in a standard war risks insurance policy. My Lords, the basic facts are straightforward, although they were serious so far as my clients were concerned. Drugs concealed on the underwater hull of the Atlantic in Venezuela, discovered by the authorities on a second inspection, not the first inspection, in August 2017. The vessel was detained under Venezuelan law, regularly to start with, and so held by the judge, rejecting our case to the contrary, regularly times thereafter. The detainment continued for 6 months. He served a notice of abandonment in June 2018.
And in relation to the 6 months, in order to establish CTL, you relied on clause 3, did you?
Absolutely so, Mark.
Yes.
Absolutely. And in a sense, I'd like to start there, if I may, because in order to set up the dichotomy which is at the heart of this question of construction and causation, I just want to identify how we put our case on loss by insured perils. Because there's an element, both in the Court of Appeal's reasoning and in the respondent's case, which seems not to give proper accord to our case. Our case for loss by perils insured, which succeeded at trial and would have succeeded in the Court of Appeal, but for the Court of Appeal's interpretation of the exclusion and approach to causation, was this. Firstly, the act of the perpetrators, unknown, in concealing drugs on the vessel's hull was a malicious act. And by the end of the trial, that was common ground. It was a malicious act because it was, if you like, a trespass or assault on the vessel involving a criminal offence, unsurprisingly, of concealment of drugs, which rendered the vessel liable, if the drugs were detected, to detainment for an indeterminate period. So it was a malicious act. Secondly, and integral to our case, accepted by the trial judge and accepted by the Court of Appeal at paragraph 32, that we had proved a loss by perils insured against as a matter of causation, was that the subsequent detainment of the vessel for a 6-month period was proximately caused by the malicious act. And whether one uses the classic language of the detection and the detainment followed naturally, which are the words one sees in classic cases like the Leyland shipping case and Lord Justice Clarke's language in the Clear-Boulos, or whether one uses language like directly following from the malicious acts, which is Lord Blackburn's language in Corrie and Burr and the Anita of Lord Denning. As a matter of proximate cause, we established that the loss was proximately caused by the malicious act. And I just start with that because your Lordships may have seen in the respondent's case, every now and again, there seems to be a suggestion that there's some fortuity which disconnects the malicious acts from either the initial detainment or the 6-month detainment. And no such case was run at trial by the insurers, save in one very specific respect, which was that their case was that we had unreasonably failed to provide security for the vessel in lieu of its detainment. A case which the judge rejected on the facts because he held that the Venezuelan authorities would never have accepted reasonable security in the first place. But I start by that, my lords, because, as I say, I just want to put these points to bed, if I may, that there are at least 3 suggestions in the respondent's case of some supervening fortuity. The fortuity of detection by the authorities, the fortuity somehow that the authorities came down very hard, unexpectedly on this vessel, and the fortuity, and this is the one which is banged on most about, if I may say so, we failed to prove lack of intent at the preliminary hearing. And just taking each of those very quickly to get rid of them, if I may respectfully say so, So far as the fortuity of detection is concerned, that's not a fortuity at all.
So as far as the fortuity?
Fortuity of detection.
Yes.
That's not a fortuity at all. That's the very reason why the acts were malicious in the first place. That there was,
I mean, it must be a fortuity in the sense it wasn't bound to occur.
it's not inevitable.
I mean, a malicious act would directly cause damage if somebody hit the ship with an axe.
Absolutely.
But if somebody leaves the front door open, it doesn't follow that a burglar is going to walk in. I mean, it's a very likely consequence. But here, if somebody attaches contraband to the ship, the whole point of that is that they believe there's a reasonable chance there won't be a detection.
Well, absolutely. Indeed, I entirely accept that. The Court of Appeal used the language of they banked on, they hoped to get away with it, they banked on getting away with it.
But your submission is presumably that it's part of the same chain of causation, and that the reason why a thief is imprisoned is that he's committed a theft, and not that he got caught,
Absolutely.
although he was not bound to get caught.
Absolutely, Muller. That's Professor Bannett's example quoted by the Court of Appeal.
Yeah.
Of course, I accept there's nothing inevitable.
But all that goes to causation, doesn't it?
It's just causation. It follows naturally and directly from the malicious acts, in answer to your Lordship's question, that if someone maliciously does an act which is liable, in this context, to render the vessel subject to detention if the drugs are found, then the finding of the drugs and the detention follows naturally and directly as a matter of proximate cause, and that was the basis upon which...
Well, that may be so, but just take my example of the thief entering the open front door. You've got two causes, haven't you? It just depends on which you're focusing. If you're pursuing the person who left the front door open, he's the cause of the subsequent theft. But if you're pursuing the thief, they're the cause of the thief because they use the opportunity. So it all depends, causation always depends on what you're looking at.
I do accept that, my Lord, and all I'm doing at the moment is I'm teeing up, if I may say so, the issue of construction that's going to arise here. Yes. The reason I'm emphasising this is that when one reads the Court of Appeal's judgment in various places, and indeed the respondent's case, they say that detainment is always on the exclusion side of the line. And what I just want to make absolutely clear is that our case was a loss of the free use and disposal of the vessel for 6 months as a result of a detainment, as a result of a malicious act. And detainment is on both sides of the line, not simply on the exclusion side of the line. And that's the point that I want to make, and it's no more than that. I accept, my Lord, that ultimately you're having to decide as a matter of construction whether we're into the coverage and into the exclusion. And in a sense, the coverage question frames the relevant causation question as well. But simply just at the outset, it is not as a matter of my case, my client's case, any form of supervening fortuity that the authorities discovered the drugs and the vessel was detained. That was why it was malicious in the first place. My Lords, very briefly, the second fortuity, which was that the authorities supposedly came down very hard.
Do you mean by that it wouldn't be malicious if they hadn't been spotted?
It would have been malicious, my Lord, but...
Even if they hadn't been spotted?
It would have been a malicious act and it would have been an offence, but in a sense, neither of those matters, either the malicious act or the offence, would have caused any deleterious consequences.
I follow that.
So the answer to your Lordship's question is it would have been a malicious act.
Yeah.
Irrespective of whether the risk materialised. It was malicious because of the risk, not because, in fact, it subsequently materialised. My Lords, there was, on the evidence before the judge and as found by the judge, this is the second so-called fortuity, paragraphs 46 and 65 in the judgment. This was the fifth or sixth case of the foreign ship being found with drugs in Lake Maracaibo in the recent past. The judge found at 46 that the drugs authorities wanted to come down hard in the face of international pressure pour encourager les autres, as he put it. The judges appreciated the need to be tough on drug crime, see paragraph 54, and hence this was the first vessel to get to the preliminary hearing. But in Shorer's case, accepted by the judge, this was entirely what Lord Denning might have characterised as legitimate political pressure, and that doesn't in any way, therefore, amount to a supervening fortuity which breaks the chain of causation. Thirdly, and finally, failing to prove a lack of intent at the preliminary hearing, my Lord, we set out to establish that the decision of Judge Villalobos was perverse. We failed. But the idea that somehow there was some unreasonable conduct on our part in failing to prove what the judge has concluded amounted to a need to disprove negligence, not only was it never pleaded or argued, but it would have been hopeless because, in fact, the ratio of the judge's decision on the preliminary hearing, Judge Villalobos on the 31st of October, was that the investigative phase was continuing because the authorities still wanted to see who the perpetrators were or might have been. And as a matter of Venezuelan law, retaining the vessel for the continuation of the investigating phase was perfectly lawful and proper. And the relevant passages in Mr. Justice Flo's judgment are 122 and 303 for the ratio of the preliminary judge's hearing decision. And the two bases for lawful detainment under Venezuelan law, investigative phase or use of the vessel in the crime subject to proof of lack of intent, is at 275. So again, there's no basis for saying somehow, as flickers throughout the respondent's case, this vessel was only detained for 6 months for consequences which cannot, as a matter of causation, be attributed to the original malicious acts. And indeed, the proof of that particular pudding was that our sue and labour claim succeeded, the premise of that being that we had acted reasonably in seeking to avert or minimise loss all the way through and beyond the notice of abandonment. So, my lords, I just want to start, therefore, by saying on our side of the line, we have a malicious act which naturally or directly causes a detainment, which causes a loss of free use or disposal of the vessel for 6 months. And on the exclusion side of the line, we have essentially exactly the same. We have a loss of the free use or disposal of the vessel for 6 months, caused by a detainment, caused by what is said to be an infringement of customs regulations. And
but the exclusion is not coterminous with the insured peril.
No, I accept that, my lord, because
that's the point about Mr. Justice Hamlin's issue 3.
I want to come back to Mr. Justice Hamlin's issue 3, but just to be quite clear, it is my submission that, as we said in the Court of Appeal, and as we continue to say in this court, that all Mr. Justice Hamlin decided was that the exclusion was capable of intersecting with a claim under the Malicious Acts cover. We accept that it is, and that is all that he decided. Now,
it's rather odd that, I mean, his last paragraph suggests that he wasn't deciding what, simply looking at the question as framed, was the question for him.
In fairness to Mr. Justice Hamlin, the matter developed orally, and he'd been set an examination paper.
Yeah.
By the time both sides got to court before him, no longer really reflected the issue. But your lordship has seen that Mr. Justice Hamlin specifically acknowledged that the argument which we then succeeded on before Mr. Justice Flo was not one that he, Mr. Justice Hamlin, was grappling with.
Well, I'm not sure that that was the very argument that Mr. Justice Flo dealt with, but at any rate, the question whether exclusion 415 covers malicious acts perils at all is one which you are obviously taking, albeit by way of alternative here, and which Mr. Justice Hamlin does not seem definitively to have decided. Have I misunderstood the position?
He has decided, as part of his decision, that the 415 is capable of applying to a claim brought under the Malicious Acts.
And you challenge that?
We've kept it alive. Let me put it that way, my lord. I mean, I was.
A moment ago, you accepted it, and
no, well,
I mean, my lord is inviting you to reconsider, effectively.
It's not a submission that I have that I wish to commend to this court. Let me put it that way.
Well, it's a submission that in your printed case you make by way of alternative.
Indeed.
And I'm sure that your judgment that this is an also-ran point is very sound, but its soundness has not yet struck me at any rate.
Well, it's not something that I'm formally conceding is the answer to the...
What I'm suggesting to you is it may be right.
Yes.
But you may be right on this point.
Yeah, well, I'm
I'm
detecting
obviously having some difficulty getting this across.
I am detecting your lordship's
It appears you may be right in not formally conceding it, and I think you might wish to think about whether you want to go further.
Well, let me come back to that. By the way. I have your lordship's point on board. All I want to say at the moment, my lord, in answer to your lordship's to what Mr. Justice Hamlin decided, was he decided a very, very narrow point indeed, and left open, specifically, issues based upon the Malicious Acts cover, because at that stage it was not common ground that this was a malicious act at all.
Right.
Let me come back to it, my lord, in the light of what your lordship has...
I mean, you would be in a slightly odd position if in relation to this claim, because the whole basis of the claim is detainment under Clause 3, which operates on the basis that we're within the realm of capture, seizure, arrest,
Yes.
restraint, etc., etc.
Indeed. And I don't want to argue against either myself or the point which my Lord Sumption has put to me, but the reality of, if I may say so, the unattractiveness of saying that Mr. Justice Hamlin was wrong on that issue is that you can effectively simply avoid the application altogether by putting the case under a different label of insured peril. And that's a point which the respondents make in their case.
Well, that may raise the question, what constitutes malice? I mean, in one sense, for instance, a capture or seizure is pretty well, by definition, malice. On the other hand, the fact that it is identified as a separate peril may entitle one to treat it as governed by separate considerations.
Yes. My Lord, having set out what we say is the correct dichotomy in this case, in any event, which is a loss of the vessel for 6 months as a result of detainment on account of malicious act on the one hand, a loss on account of detainment as a result of what is said to be the infringement of customs regulations on the other hand. I'd like now to deal with my submissions, if I may. And my Lords, I'm not in the time available.
Sorry.
I don't want to repeat what's in our written case, and unless your Lordships want me to go to particular authorities, I'm going to effectively try and develop the submissions without reference to going to the authorities, unless your Lordships want me to go to any in particular. And what I want to do is I want to develop my submissions under the following heads. Some short submissions on the approach to construction, then deal with the language of the policy, then deal with business-like considerations, then deal with the legal context for the institute clauses which were issued in 1983, then causation, and then what we say is the proper scope of the exclusion. And my Lord, taking those in turns, let me start with the approach to construction. I'm not going to take any time up with well-known principles of construction. All of your Lordships have been there in many cases. We set them out in our case at paragraph 16 insofar as necessary. What I would like to do, however, is deal with the specific points on the institute clauses themselves, which your Lordships have got in tab 10 of the appendix and in the electric bundle at 370, if you prefer that reference. But it's tab 10 of the appendix, page 192, is where one has the exclusion clauses and the insured perils, and I shall develop the language. But can I just make these general points, first of all, about how one should approach the institute clauses? First of all, my Lords, the clauses have developed incrementally over time in a fairly piecemeal fashion in response to particular problems as and when they've emerged. As Lord Justice Lloyd said in The Wondrous, they weren't drafted by equity draftsmen and therefore shouldn't be interpreted, as it were, as if they have a overarching coherence. Secondly, they have developed incrementally in connection with changes to the marine policy, the hull policy, if one wants to use that expression, which is going on at the same time. So for example, if your Lordship looks at clause 417, which is a new exclusion to do with piracy, but this exclusion shall not affect cover under clause 1.4, sometimes the insurers say, well, that's interesting, why are the words in parenthesis in 417 and not in any of the other exclusions? And the piracy exclusion 417 is added in 1983 because in 1983 at the same time, piracy is coming out of the war policy. It's going into the hull policy as a specific. and although piracy is going into the hull policy, riots are still staying in the war policy in clause 1.4. And the problem with piracy and rioting is that there's a definitional interrelationship, because pirates can be rioters or rioters can be pirates. And therefore, you need to make plain, for example, in 1983, when you're putting piracy into the hull policy but keeping riots in the war policy, that the exclusion for piracy won't affect what amounts to a riot, which in 1983 was a group of 3, and in 1986 became a group of 12.
Sorry, so which way around it is? The hull policy excludes piracy.
No, in 1983...
in 1983, yes.
What happened before 1983 was that the FCS warranty excluded piracy from the hull policy. In 1983, they make a change. They put piracy from the war policy into the hull policy. They then have to make consequential changes. And there's a definitional problem about piracy and rioting. And I just give that as an example of what was an incremental change to the exclusions specific to a change in the hull cover in 1983.
But piracy was excluded from the FCS because they were assailing thieves, was it?
Yes.
Yeah.
But in 1983, it's moved from the war policy to the hull policy. My Lords, the third point on approach to these clauses is a significant one in my submission. As Lord Justice Lloyd said in The Wondrous, and I'm not going to go there unless your Lordships want me to take you to it, there's a passage at 572 in The Wondrous. It's a mistake. It's a mistake to treat the exclusions as if they are somehow providing exceptions to liabilities in specified circumstances, rather than as identifying the sort of arrests or detainments which the draftsman had in mind as falling within the scope of the cover. And that's what Lord Justice Lloyd said in The Wondrous. You obviously have to read the exclusions and the perils together, but there's an element of the submission of the insurers which says at various places, well, this exclusion or these exclusions must be assumed to be looking at interdependent causation, where you are in the cover but for the exclusion and therefore are taken out of the cover by the exclusion. And in my submission, that's too legalistic an interpretation of what the draftsmen were intending to do. Take the positive case that was being run by the insurers in this case, based on clause 416, which was a failure to provide security. The insurers said there came a point where even if we, the insurers, are wrong on exclusion 415, you acted unreasonably by failing to provide security. And that failed on the facts. But assume hypothetically that that had succeeded on the facts, what would be the analysis of the continued delay after we had failed to provide ex hypothesi reasonable security? One might say, as the Court of Appeal would have said in the Elisa Glacial, 2 proximate causes after you unreasonably failed to provide security: the original malicious act and a failure to provide security. Or they might say, and this was the approach that Lord Justice Christopher Clark took at paragraph 49 in the Court of Appeal, no, once you unreasonably fail to provide security, the sole proximate cause of the continued detainment is the unreasonable failure to provide security. Now, if that analysis is right, that latter analysis, insurers might say, well, we don't need the exclusion at all, because you're outside the scope of the insured cover.
No,
but,
I mean, that must be a fallacy.
It's a fallacy.
Because, as I said earlier, the very inclusion of an exclusion means you're operating in a different ballgame.
Exactly.
Your focus is on now something else.
Indeed.
Yeah.
I mean, you can't approach these clauses on the hypothesis that you are you have to construe the clauses to have a meaningful effect, which means that you're in the peril and taken out of it by some form of independent causation. The draftsman is intending to identify the sort of detainments in this context which are intended to be in or to be intended to be out. And that's what, if one goes back to the opening words of this clause, of the Institute clauses, so on the very first page of the Institute clauses, perils, clause 1, subject always to the exclusions hereinafter referred to, this insurance covers loss or damage to the vessel caused by. Those words, subject always to the exclusions, are intended to reinforce the importance of reading the perils and the exclusions together, as Mr. Justice Hobhouse said in The Wanderers. They're not giving primacy as a matter of construction to the exclusions over the insured perils.
Do you make that submission in relation to all of the exclusions? I mean, some of the exclusions lend themselves more readily to that submission than others.
Yeah, I accept that, my Lord.
415 clearly can be said to lend themselves to that analysis. On the other hand, 411, 412, 417 maybe less so.
Well, I would certainly see that 42, for example, it looks like a classic exclusion of that
Yes.
of that sort.
It's something that's prima facie within the covering clause, but then taken out again.
But certainly, so far as, I mean, in a sense, it goes back to the Mr. Justice Hamblin point in one sense, but not entirely. Certainly, clause 415, with its focus on arrest, restraint, detainment, confiscation or expropriation, is to be read alongside, specifically 1.2 and 1.6, as identifying the sort of arrests, etc., detainments, etc., which the draftsman has in mind. My Lords, fourthly, as a matter of generality, we accept that the Institute clauses are for worldwide use, but there's nothing parochial or domestic or turning on any niceties of domestic, either English or Venezuelan law, inherent in our case. This is a point of general application. What happens when a malicious actor or a terrorist does an act which puts the vessel into trouble with customs? This isn't turning on some obscure parochial issue of any sort. Fifthly, notwithstanding the importance of the language of the clauses, there is authority in construing these exclusions in a businesslike and non-literal way, and we set this out in our case at paragraph 18. But if you again look at clause 416, that exclusion, read literally, talks about failure to provide security or any financial cause, and we know from the Elisa Glacial that security means reasonable security. We know from the Elisa Glacial that any financial cause can't be taken literally. See Mr. Justice Towson's example of the terrorist seizure demanding ransom. And we also know from the Elisa Glacial that although trading regulations in clause 415, read literally, could be given a very, very wide meaning indeed, it must be subject to some form of generic limitation focusing on the nature of the regulations rather than the fact that the vessel is engaged in a particular fishing trade in that case. So again, there's form for reading some of these exclusions down. My Lords, the final point of general application, I don't want to take long on it, but there's a point on whether this is construction or implication. We say that we are construing words which are in the policy, and in particular, what is the meaning in the sense contemplated by the policy of the words by reason of infringement of any customs or trading regulations. And so as a matter of construction, we say you have to ask yourself, as they ask themselves in the Elisa Glacial and other cases, what is the meaning of those words as a matter of context and language, background, common sense, etc. It's not a matter of implication, even though the effect of construing security as reasonable security is, of course, to imply some limitation into the words. But, my Lords, even that's wrong, and again, I don't want to take time up on this. We know from the Marks and Spencer case and cases that have followed that implication still raises broadly similar questions of commercial common sense and surrounding circumstance. And if I'm pushed, I will say, with respect, that our construction and our approach to by reason of causation is an obvious one, which goes without saying within the format of the implied test term. But my primary submission is that this is a question of construction rather than implication. My Lords, the starting point of any question of construction is, of course, the language of the policy. And we set out submissions on this in paragraphs 20 to 28 of our case. My Lords, the relevant question is the language of the policy, reading the perils and the exclusions together, not just the language of the exclusion. And the starting point is that the language of the perils, and in particular the relevant peril under clause 1.5, any terrorist or any person acting maliciously or from a political motive, is comprehensive and unlimited. It effectively seeks to cover all possible bases of deliberate hostile motive. The exclusion, by contrast, is not explicitly directed towards either any infringement howsoever arising, or indeed to the malicious acts cover at all. It's not explicitly directed. It is obviously directed at certain types of detainment, but it is not directed, at least specifically or expressly, to classes or types of malicious act or terrorist act. And there is therefore a tension between the wide construction of the exclusion clause and the apparently unlimited or comprehensive scope of the terrorism and malicious acts cover, because the terrorism and malicious acts cover purports to apply to any terrorist or any person acting maliciously or from a political motive, whereas the insurer's case entails that whereas the acts of some terrorists and some malicious actors who do criminal acts, for example, murder on board the vessel, acts in breach of public or administrative laws, smuggling of people or literature, and who cause detainment and loss, those will be insured. On the other hand, insurer's case entails that other terrorists or malicious actors who do criminal acts which happen to put the vessel into trouble with customs or quarantine and who cause detainment will not be the subject of the cover.
Is that submission made on the footing that any criminal act, other possibly than one involving strict liability, is to be regarded as malicious?
A criminal act if one ignores strict liability, and again, my Lords, ignoring perhaps a criminal liability which would arise negligently,
yes,
without malice, I'd have to take that out of the equation.
Let's take
well.
a deliberate criminal act.
A deliberate criminal act, recklessly indifferent, which is our present context, to the consequences of the act upon the vessel.
So it doesn't have to be targeted. The malice doesn't have to be directed against the ship owners.
No, it doesn't have to.
It's enough that they are indifferent to the consequences to the collateral damage that might be caused.
That is so, but in the old cases there was suggestion that spite or ill will was required,
right.
But the law has moved away from that.
Is that old cases on this particular clause?
No.
Because, I mean, it does, if you stood back and asked, does smuggling have the flavour of terrorism or of someone acting maliciously or from a political motive, you might not think of smuggling naturally. I mean, for the reason I think my Lord is putting you, the main aim is not to damage anyone, it's to make a lot of money by the smuggling. And similarly, if somebody overloaded a ship, I mean, that may be illegal, it may render it liable or something liable to confiscation, but you wouldn't say that they were acting maliciously in the ordinary sense, would you? You would say they were just acting illegally. Well,
take your overloading example, my Lord. If they deliberately overload the vessel for effectively illegal reasons, knowing
just
of the illegality.
Say you overload because you carry more cargo.
No, but in my submission, if you deliberately overload the vessel knowing of the potential risks to the vessel and deciding, well, if the ship goes to the bottom of the sea as a result of being overloading, so what? And maybe extreme example, that would be a malicious act. Smuggling...
I mean, there aren't any cases on this. I think it seems to be common ground that what happened here can be brought within the words person acting maliciously. I think the proposition I was putting was that it's not the most natural association.
Unless you go forward to recklessness. I mean, indifference as to collateral damage, I see the force of the point that
He's reckless.
That.
Yeah.
But, I mean, I would certainly find, I don't know whether it's to be found somewhere in this material. I mean, I'm not for one moment trying to go behind the common ground.
No.
But I would certainly be assisted by knowing what the legal basis of the common ground is in the case law, in particular relating to recklessness. So if at some stage I could have a very short note on that, I would be much assisted. It may even be possible to agree it, since this was common ground below.
The references, the authorities, are at footnote 5 to our case, my lord, on page 2 of the case, 93 of the appendix. So it's Mr. Justice Coleman, the Grisha Express, Mr. Justice Coleman in North Star, and then there's an old case, Pesquaris, citing Allen and Flood.
Okay, well, that's my note then, thank you.
I mean, I'm not sure I can give the Lordship any more chapter and verse.
If it's here, I'm happy.
What Mr. Justice Coleman said in the first case, my Lord, is that it was appropriate to use a test of recklessness derived from the Malicious Damage Act. And those cases like, for example, Cunningham, famous case.
But why has crime got anything to do with it?
Sadly, my Lord, many of these concepts, I understand your Lordship's question, but many of these concepts are construed in the marine insurance context by reference to criminal law.
So is it your case that in order to be malicious, it also has to be criminal?
The answer may be, the answer, my Lord, is it may well be wider than criminal. In this,
the criminality may not be the essence of it, but it's actually hard to think of loss or damage inflicted maliciously, which would not be criminal.
No. Well, is it?
Economic loss.
Quite.
Well, it's loss or damage to the ship that we're talking about.
Yes. If somebody by some device arranges for the ship to be unable to sail when it should, so that it costs the owners a small fortune, that may very well be malicious in the sense that it's done with evil intent. It doesn't remotely follow that it's a crime by English law, Venezuelan law, or anybody else's. Does it?
The trouble with your Lordship's question, if I say so, is that this is, because this is a policy on the hull, effectively,
Yes.
and doesn't respond, as it were, to economic loss of earnings through delay and so forth, it may be hard to envisage a loss of the vessel by malicious acts through detainment, which does not involve criminal act. But
Up to you, of course.
But I'm not...
But I thought if you
the use of the expression malice or malicious in English criminal law has varied over many years and has more or less disappeared.
Yes.
It's still there in the Offences Against Person Act, and the Malicious Damage Act disappeared years ago.
Yes. For our purposes, my Lord, I mean, firstly, it is common ground that this is a malicious act.
Quite.
So I'm not trying to duck your Lordship's question. And secondly, this was criminal.
I don't think my question actually arose out of anything you said.
I mean, the critical point here is that the Institute clauses cover loss of or damage to the vessel.
Yes.
And so we're not talking about economic loss.
In this case, the loss is a loss by detainment, as I've already submitted.
Yes, I mean, you could, in my Lord's example, you could detain it to the point where it became a constructive total loss.
Yeah.
You could, my Lord, and indeed...
Well, I suppose if you were blockaded in the Shatt al-Arab for more than a year, it would not necessarily constitute malice. Well, I suppose it might, yes, it would be within the clause, although there would be no criminal act involved. It would simply be a war.
On our facts, my lords, I'm not trying to duck this, but on our facts, this was criminal, and it was a malicious act. And that's the common
Well, there's
ground.
certainly been vessels detained in various parts of the world by judicial process, where the instigation of the judicial process could be regarded as malicious.
Well, one's now going to get into examples of put-up jobs, which obviously I'm going to have to come back to in another context, but one could have those sort of examples. Yeah. So, my lords, just on language, before moving on, we say that the effect of the insurer's construction is that it does produce a tension between the comprehensive nature of the insured peril, which we've discussed, and the wide construction which insurers contend for, because there will be terrorists or malicious actors who do acts whose stratagem or overt acts involve getting the vessel into trouble with customs, and that will mean, on the insurer's case, that loss caused by those terrorists or those persons acting maliciously will not be within the subject of the cover. And so I don't accept, as a matter of textual analysis, that the insurer's construction of the clause accords with the perils and the exclusions being read together. Now, obviously, one's got to go on to wider considerations of business-like interpretation and commercial common sense. But simply as a matter of language, there's a tension which one didn't have, for example, take a recent case of impact funding which came before this court, which my Lord Hodge gave the leading judgment, where there is a symmetry between an apparently unlimited scope of the insured peril and the argument that the construction should be given a natural effect to. Here the exclusion is being relied upon to cut down what on the face of it is important and unlimited cover. So, my lords, that turns, if I may say so, to the next topic, which is business-like interpretation. And one has to start always by recognising there are two ends of the telescope in any question of construction and in any question of business-like interpretation. And one needs to approach it, I accept, in an even-handed way. Insurers' end of the telescope, they say, is emblazoned with the slogan, "Smuggling is not a war risk." And we say that's too generalised a proposition in any event, and I'll come back to that. But emblazoned not simply on the opposite side of the telescope, but we would say on both sides of the telescope, because this is, after all, a product being bought and sold as war risk insurance, is the proposition that malicious acts, terrorist acts, are a war risk in this policy, and indeed under the Institute clauses in 1983. So one doesn't advance the argument of construction or resolve the dichotomy between exclusion and insured peril simply by saying smuggling is not a war risk, even if that's true in its comprehensive form, which we say it's not. What your lordships have got to ask yourselves, in my respectful submission, is this. If a terrorist or a malicious actor does a hostile act which puts the vessel into trouble with customs or quarantine or trading regulations, whichever the particular regulations we're talking about, which is the more businesslike and common sense dividing line? Is it realistic to think from a businesslike perspective that the parties would have said, we'll cover you against terrorist acts, malicious acts, other hostile acts, but not if it happens that those acts put you in breach of customs or quarantine or trading regulations? Or, in the alternative, as we say, we will cover you for terrorist or malicious acts, even if they happen to put you into trouble with quarantine or customs or trading regulations. And we say that the dividing line that we espouse is the sensible, common sense, commercial, business-like one, and the dividing line that the insurers espouse is not. And one starts with the proposition again that this is an insurance against loss caused by any terrorist or any person acting maliciously. It is common ground, as I've already submitted, that if a terrorist or malicious actor does an act which causes detainment and loss by putting the vessel into trouble with criminal authorities, immigration authorities, political authorities more generally, that will be an insured loss. It is also common ground, my lords, that in certain factual circumstances, if a terrorist or malicious actor does an act which involves concealing drugs, quarantine materials, weapons on board a vessel, as a result of which the vessel is detained, the cover may respond, depending on the precise facts involved. And I say it's common ground. Mr. Edelman will say, well, these are very unlikely factual scenarios, but there's at least two scenarios that have been identified thus far in the case where the presence of drugs or weapons which would otherwise be the subject of trading sanctions or whatever may be found on board, may nonetheless, if leading to detainment, give rise to an insured loss. One example, which the Court of Appeal accepted at paragraph 40, and which the respondents appear to accept, although maybe they don't formally accept, is that if the intended stratagem of the smuggler or terrorist is purely domestic in nature, so it's not envisaged that the drugs will be transported across customs boundaries at all, or that the weapons will be used overseas rather than, for example, at a terminal at the load port. Seems to be accepted that if drugs are found and the stratagem is purely domestic, then the infringement of customs regulations or quarantine regulations, if it's a substance which would infringe quarantine, would not be triggered. The other example, which is still accepted, is the example of a put-up job, as the words have been used, in inverted commas, where either the government or some political authority or perhaps a third party intends that the vessel should be detained and the detainment manifests itself.
And do you say it's common ground whether the put-up job is put up by the authorities or some entirely unconnected third party? Or are they different?
The way it developed at trial was the common ground was the government doing it.
Right.
The judge then gave examples of the third party either wanting the vessel to be detained or blackmailing the vessel, saying...
Yes.
And I'm not sure it was formally common ground at trial. I don't want to put words into the insurers' mouths here, but I don't understand from their case, at least at the moment, that they're drawing a distinction between those different types of put-up job. They give explanations for it, rationalisations for it. In my submission, in answer to your Lordship's question, it's difficult to see, really, how one could say that a put-up job by a government agency would trigger the cover, but a put-up job intending that the vessel be detained pursuant to a tip-off or whatever it is by a third party should not. So,
there is a distinction, isn't there? I mean, consistently with the sort of argument on the respondents' part that we were attacking earlier this morning. Namely, in the latter case, they would say, well, it's not inevitable that the government will latch on to what's going on. If you do hypothesize the rather extraordinary situation of someone setting out to put contraband on a vessel, not with a view to smuggling it, but with a view to it being caught, and the government then acting, that's not inevitably going to happen. As far as the world is concerned, presumably it'll actually look like a smuggling operation. Well, you never discover the intention of fixing the contraband to the hull was actually to spite the owners.
This is the point, though, with respect, my Lord. I mean, at the moment, I'm simply identifying that there are put-up jobs as well as domestic stratagems. Yeah.
If it's put up by the government, then you can say it's inevitable. I mean, they intend to. They put the. It's the sort of thing which occasionally the police are accused of.
But it may be one.
Well just go in and pinch the vessel.
Right.
I'm just wondering if there's any breach of the customs, any infringement of the customs regulations at all. If the government puts the cocaine on the ship.
Well, the trouble with these examples, my lords, is that
they're pretty fanciful examples, aren't they? Well, I mean, are we really testing the wording of this policy by reference to these extraordinary possibilities?
It's not fanciful, in my respectful submission, to envisage a case where a vessel is arrested with drugs on board, which may have been the result of a tip-off to the authorities. It may have been the result of a tip-off by a member of the public. It may have been a member of a rival cartel, for example.
Yes.
Or it may even, my lords, and this gets getting closer to home, it may have been the cartel itself who says to itself, well, the government needs one success a month to effectively show the world that it's coming down tough on drugs, and the next 4 or 5 of my shipments will escape unscathed.
Well, it's commonly a grass within the criminal gang doing it. That's the normal situation, I think. When there's a tip-off.
But I rather like Mr. Schaff's last example of the commercially orientated gang.
Well, it's not inconceivable.
It's not inconceivable at all.
But the question I was asking was slightly different.
The question your lordship was asking is
Yes.
is there a distinction, and is it conceded, I think was the question that your lordship was actually asking. And I have to say, I'm not sure that it's challenged, but I don't want to put words in my learned friend Mr. Edmund's mouth, of course. My submission is that there are circumstances, and they may be extreme circumstances, but the problem is that one will never ever know what the true facts of any given case actually are. Even on our facts in this case, we have no idea. It's said, well, why was there a second inspection? Who knows whether on the facts of any given case there was a tip-off? Who knows who tipped it off? Who knows, take the government example, which your lordship has put into me, who knows if there's someone in the government with one agenda, the authorities, the customs authorities, perfectly bona fide, receive a call, don't know who it's from, go and inspect, find the drugs, there's an offence of concealment under section 31 of the drugs law. The courts then act perfectly bona fide, wholly ignorant of somebody else's stratagem. Now, the only point I'm making at the moment, my lords, is that, of course, these may be extreme facts, but there are circumstances. This is not a case where one can say there is a bright line. Any drugs found on board the vessel will involve the operation of the exclusion.
Can you tell me what is the legal basis on which it is being suggested that a put-up job would not be within the exclusion?
The legal basis which was submitted to the Court of Appeal and accepted by the Court of Appeal, there's a gloss on it now in the respondent's case, but the case that was put to the Court of Appeal and accepted was that a put-up job involves inevitable loss, inevitable detainment.
No fortuity.
No fortuity. And so it's this distinction, but which underlies a number of the questions from a number of lordships, that there is some distinction to be drawn between inevitable loss and simply loss arising naturally and directly because the drugs...
Well, why is there no fortuity? Because, it may, once you have a put-up job, it may be inevitable that it will result in the detention of the vessel, but it's still a fortuity that there is a put-up job. If you take a terrorist act, for example, it may be inevitable that once you plant a time bomb in the hull of a ship, it will blow up. But it's not inevitable that someone's going to plant a time bomb in the hold of the ship.
Well,
it's still a fortuity.
There is a fortuity. The argument of the Court of Appeal, which we challenge, of course, is that as a matter of causation, the detainment is not by reason of the infringement if it's a put-up job, but it is by reason of the infringement if it is simply a malicious act which entails the risk.
You've been addressing fortuity on the question of whether it breaks the chain of causation or not, haven't you?
And it doesn't break the chain of causation.
And you said it doesn't.
It doesn't break the chain of causation, but just as it doesn't break the chain of causation, we say that the so-called fortuity of detection, just focusing on detection, which doesn't arise with the inevitable detainment, but only arises with the reckless detainment, the so-called fortuity of detection doesn't eclipse or diminish the causative potency of the original malicious acts, nor does it enhance the causative potency of the infringement, because the infringement and the malicious act are both the act of concealment. Neither of them have any causative consequence without detection. And therefore, if it's to be correctly characterised as a fortuity of detection because there's nothing inevitable about finding the drugs, it doesn't advance the argument one way or the other in saying, well, we're into the exclusion rather than into the out of the insured peril or whatever.
I mean, in the case of the classic narrow put-up job, the government of a country decides that it would like to get that vessel. It plants some drugs on board and then next day confiscates the vessel for customs, breach of customs regulations. Surely, although there's a person acting maliciously, that remains the dominant, inevitable cause. And I think you can fortify that by reference to 4.1.4, because it is in essence a capture, seizure, etc., by government, but not by the government of the country in which the vessel is owned or registered. So you get a sort of flavour that from that it's not going to be excluded. There would be cover in that situation, because it's the equivalent of the government just laying its hands on it. They've just found a pretence.
No, I see that, and in a sense, the commercial examples of the which goes back to Lord Hughes' point, the commercial examples of put-up jobs given by Mr. Justice Flo of the cartel, which effectively tips off the authorities for its own commercial purposes, intending that the vessel should be detained, are obviously, in one sense, more apposite, because there is a commercial motive of some sort. I suppose it might be said conceptually, well, is it inevitable that the authorities will act on that tip-off? But in reality, if that's the stratagem, then it is to all practicable purposes inevitable that the ship will be detained. And one has to ask, well, if you accept that as a matter of common sense causation, the terrorist plot or the malicious act plot is the one which is effectively the common sense cause of what's happening here, why and how can you distinguish that case between the case which we are assumed to have on our facts, where there isn't anything intentional about the detainment, but it is simply the reckless consequence of the original acts? And we say, and we set out some detailed submissions on that in our written case, that you can't draw a distinction as a matter of common sense or causation between intentional acts and reckless acts in this context. And my lords, I don't want to labour this because there are other points to deal with, but the insurer's case on this exclusion does contemplate, firstly, that it makes all the difference in the world to whether the loss is insured or excluded, depending on what, colloquially, one might say, what's in the box. If a box or a package is concealed on board a vessel, which the ship owner knows nothing about whatsoever, if the contents are prescribed literature, or if it's a big crate hiding a political refugee or a criminal, and it's discovered and the ship's detained, that's insured cover. If the contents happen to be prescribed goods like drugs or quarantine materials, then there'll be no cover. So cover turns on the happenstance, so far as the owner is concerned, of what's in the box. Secondly, so far as drugs are concerned, or possibly weapons subject to trading sanctions or whatever it is, it's going to turn ultimately on factual distinctions as to whether there was a domestic stratagem or an international export stratagem, or whether it was some form of put-up job. And we say, my lords, that there is no business-like sense in drawing these distinctions and the evidential problems of ever knowing whether there's been a tip-off, who gave the tip-off, for what purpose was the tip-off made, identify how unlikely it is that this sort of dividing line should be drawn. So we submit...
Isn't it always the case in sophisticated structures of this kind where you have a policy clause and an exclusion clause that you can see reasonably clearly where they are centrally aimed at, but they will have very difficult edges. A line may have to be drawn somewhere, and one can't always come up with a completely business-like line from top to bottom.
I do accept that, my lord, and I acknowledge that one needs to get to the substance of the issue of construction in this case. But we know from today's world that terrorism and malicious acts as well can operate in so many different ways. And we are starting from a policy which purports to sell comprehensive terrorism and malicious acts cover. And
can I ask you a question about that? I think I've seen, I'm sorry, you can come back, but finish off and I'll come back.
Well, all I was going to say is that is the starting point, and that therefore, although it's right to say, well, you shouldn't be looking at theoretical terrorist plots, extreme examples of terrorist plots, extreme examples of malicious acts plots, and so forth. The aim of this cover is not to, as it were, put the microscope of the actor under the, put the motive of the actor under the microscope, and effectively draw fine distinctions between different types of terrorist or malicious act plots. That's my answer to your lordship.
Certainly not under the coverage clause, but then if it's, once one accepts, if one does accept that 4.1.5 invades that generality, there are bound to be jagged and difficult lines at the edge of the invasion.
My submission to your lordships is ultimately going to be that the invasion of the malicious acts cover is subject to my Lord Sumption's question as to whether it permits an invasion at all.
Yes, that's why I made my slight reservation.
Is a very narrow invasion at all, because you can give effect to that invasion not by drawing distinctions between different types of terrorist or malicious act strategy, but by treating the relevant invasion as requiring an infringement of customs regulations, which is independent of the malicious acts.
No third party, someone on the ship.
No third party, someone on the ship, or an entirely innocent infringement, which has nothing to do with the malicious acts at all. Because it's not my case that the clause only applies to a deliberate act. It can also be an unintentional infringement done by someone who makes a mistake in shipping goods on board which are in fact prescribed, or bringing them on board which are in fact prescribed. So that's the qualification.
Yeah.
That's not so much an invasion, is it? It's just sort of an explanation of that not coming within cover. Which of the policy clauses would that sort of conduct come within?
But that goes back to the point I made earlier, my lord, which is, in a sense, one mustn't approach these exclusions as if one's trying to find subtraction.
No, but if, of course,
No.
And there may be aspects in which an exclusion simply tells you that it's not within any of the coverage clauses.
Indeed.
But if one gets to the stage of seeing that there is some scope for invasion, that seems to me where the difficult jagged lines may be a fact of life.
I accept that, although my answer, again, to your lordship, is that in trying to construe what invasion there is, one needs to construe that in a business-like way commensurate with the width of the cover that you have provided, and that although one approaches exclusions very often with the view, well, the purpose of the exclusion must be to subtract something which is in the intersection of the two circles, or whatever it is. That's not the way I respectfully submit. These exclusion clauses, particularly 415, are really set up to do what they're trying to do is they're trying to identify the sort of detainments, the sort of confiscations which the draftsman intended should be insured or excluded. And if you've got a 415 clause for terrorism cover or malicious acts cover, and you can construe 415 as dealing with independent infringements which are independent of the malicious acts and not the malicious acts themselves, that's the best way of harmonising the tension between the two.
So it differs, for example, does it, from 412, which is the exclusion of war between the 5 permanent members of the, or involving any of the 5 permanent members of the United Nations. Is that a true exception?
I think you accepted it was.
I think that is, yes.
That one is.
Yes.
So you've got both sorts.
But there are definitely both sorts of exceptions.
Okay.
So, my Lord Mance, I think, was
Yes, well, my question was, how much smuggling cover is there under this policy on your interpretation?
On my,
quite a lot. I mean, because 4.1.1.5 doesn't exclude any sort of smuggling, whether it's by someone on the vessel or someone not on the vessel.
on my case, my lord, smuggling is is excluded if it's done by the owners.
Well, of course, but that's a different principle. You can't recover in respect your own fraud, effectively, loss which you've caused yourself.
But neither the mortgagee, for example, the mortgagee couldn't recover. Right?
Mortgagee could recover. So the mortgagee can recover if this is put in a mortgage policy.
If it was done by somebody on the vessel without the privity of the owners, it would be barratry under the time clauses.
Indeed.
Well, but it would still be covered under this policy, wouldn't it? Why wouldn't it be covered? It's a crew malicious act. So you'll have double insurance.
No, my lord, because a malicious act, and again, a malicious act does not include an act done by the barratrous act of the crew.
That's Mr. Justice Coleman.
And that's Mr. Justice Coleman. And indeed,
Why does it not include barratrous act?
Because it's an example I would submit, and this is what Mr. Justice Coleman held, and
Reading
it's what
the two.
you've got to read them together. You have to construe these clauses, both the perils, the exclusions, and the whole clauses together, to make sense of the A, the cover being provided in the war cover, and B, the universe of cover being provided both by the whole cover and the war cover. So I accept that read literally, you say to yourselves, well, why is an act of a crew member not a malicious act? But you have to read malicious act down to effectively remove acts prejudicial to the owners done by the master officers or
What, because it's covered under the time clauses?
because it's covered under the time clauses as barratry,
Yes.
and because there's an exclusion under the war policy for anything covered by the hull policy.
Under the current
4.2,
form
is it?
Yes.
of the Institute clauses, the old division between war risks and hull risks was relatively simple, because you had the FC&S clause, and everything that was excluded from the Institute time clauses by the FC&S clause was covered by the war risks clause. But the perfect interlocking between the two insurances is no longer so clear since the new forms came into being with separate codified lists of insured perils.
I'm not sure it was ever completely perfect, even before that, and one had this question of proving what was in the hull cover and proving what was taken out.
Linguistically it was, because the old form of war risks cover simply said that it covered all perils which were excluded from the Institute time clauses by the FC&S clause.
Yes.
So while you might have difficulty in working out whether it was or wasn't excluded, there was no doubt that there was a perfect division between the two. You were either in one category or the other.
I mean, in principle, Lord, that's right. I'm not sure even then whether it was entirely perfect, but in principle, that was the way that the division worked.
And presumably, just looking at the interrelationship now, you've got an implied exclusion of barratry because, well, primarily, presumably because of 4.2, it would be recoverable. But what is not recoverable under the Hull policy is barratry where there has been a want of due diligence by the assured. So that if you fail to inspect the vessel sufficiently closely at the load port to preclude smugglers smuggling goods on board, you wouldn't recover under your Hull policy. On your argument, you would recover under the war policy, because then it would be a person acting maliciously who wasn't excluded because there was no hull cover.
No, sorry, my Lord.
Well, why not? Why not?
The exclusion applies.
No, well, it doesn't. The exclusion only applies to things which would be recoverable under the Hull policy. But if there's been a want of due diligence, then the barratrous loss is not recoverable under the Hull policy.
No, but forgive
so
me,
on your argument, it would be recoverable under the war policy.
No, Molly, it wouldn't be recoverable because of clause 415, because we accept clearly.
Well, why does it suddenly become a loss by infringement of customs regulations then, rather than by malicious act?
Because malicious act does not include a barrattress act. That's the first proposition. That's Mr. Justice Coleman and Mr. Justice Flo.
Well, I don't understand why not. It's the most obvious sort of. By definition, it's much more barrattress than a third-party smuggling because, by definition, the crew are acting contrary to the interests of the owners.
I mean, it's a case of barratry model, and that goes back to the point that I'm making, which is that, as Mr. Justice Coleman said, and as Mr. Justice Flo said, malicious act does not include the act of barratry by master, officers or crew, and therefore the malicious act must be by someone who is a third party.
I know, but that's just assertion to my mind. I don't understand what the reasoning is. It seems to me the most natural sort of malicious act. I can understand reasoning which says it's excluded from this policy because it's covered under another, and that seems to be the effect of clause 4.2. But it's not completely covered by the other, so I was asking why doesn't it fall back on this one?
Well, because my lord, I only give the
You don't get to the premise.
I can only give the same answer with respect. Firstly, we say that the definition of malicious act, in the light of the Grisha Express, where Mr. Justice Coleman specifically says that if you've got a policy against malicious acts which doesn't cover against barratry, then you, the owner, have effectively, if the point is raised, to negate the possibility that it's barratry in order to come within the malicious acts cover. So in other words, as a matter of construction, reading the malicious acts cover and the whole cover together, a malicious act must be an act by a third party and not by a member of the crew or an officer or the master. Now, my lord, that's the only answer I can give your lordship,
No,
because it is my submission, just that there's absolutely no ambiguity about this. It is my submission that by reason of infringement of customs or trading regulation applies to smuggling by the owners and applies to smuggling by master, officer or crew. And the reason for that is because those are not malicious acts within the scope of clause 1.5, because a barrattress act is not an act which, reading the covers together, falls within clause 1.5 at all. That's my answer to your lordship's.
Even if it wouldn't be covered under the hull clauses, because it has resulted from want of due diligence by the owners or managers.
Indeed. So if one takes a case of the Anita, which frankly, when one reads the facts of the Anita with hidden compartments and so forth, might have come quite close to a finding of privity on the owners. But if one takes the facts of the Anita and says, well, assume it wasn't privity, but there was a clear want of due diligence by the owners because they never inspected these hidden compartments or took steps to find out what was going in there, we would say that that's a classic example of the intended application of clause 415. And if, in today's world, there is barrattress smuggling in which there is a want of due diligence, you're not in the hull cover, but you're also not in the war cover because of an Anita-type exclusion 415. And the distinction between the Anita and this case is that the Anita was crew smuggling, and our smuggling in this case is smuggling by the malicious acts of a third party. And that's my answer.
So that owners' want of due diligence cases would be excluded under 4.1.5.
Yes.
Prima facie covered, but under 1.2, but excluded under 4.1.5. Now, the other question I wanted to ask was that in the respondent's case, there's reference to evidence which they say was put in from your broker, Mr. North. Ignore his views, but his factual evidence was that separate specialist cover was available in the present type of case. What significance does that have?
My lord, there was an attempt to put this into the Court of Appeal and it's persisted in. The answer is that this is the position in 2007, not the position in 1983 when the Institute clauses were agreed. So that's the first point. Yes. So it's impossible to see how this material, which the insurers still try and slip in, is relevant to the construction of the 1983 clauses.
So we're construing the 1983 clauses by reference to the intention of a person adopting them at the time of the contract, not necessarily the same as the
I do accept that, but in my submission, the meaning of the Institute clauses does not change in this regard between 1983 and 2007. So that is my first point. The second point I make in response to this is that I don't think anyone's tried to slip in the relevant cover, which was sought to be put in before the Court of Appeal. And I don't really want to give evidence, therefore, in relation to a document which isn't before the Court. But it covers all sorts of things. I'm not sure quite at the end. My answer to your Lordship's question is it does not provide any meaningful assistance to the question of construction that arises in this case. It's not in evidence, and therefore I can't make submissions on it.
Right.
But
anyway, overlapping covers are to be found all over there.
Indeed. I know it's a prejudicial point, and your Lordship's dismissed the opinion already, but the broker was wrong on my case. And the passages in Arnold, it's interesting because the clear voulos of roads, which I'll have to come back to, which was the 2000...
Yes, so Arnold has two statements which are in your favour on issue 3.
Indeed. Well, not just on issue 3, but also on this point, because answering the question which both your Lordships have put to me about, well, we're looking at the context in 2007 for the proper interpretation of these clauses. In 2007, both before the clear voulos of roads had been issued in the 3rd edition and after, in the 16th edition, and after the clear voulos of roads in the 17th edition, Arnold is still saying, well, these clauses do not apply, they're only directed at the 1216 insured perils. So there is no settled perception, indeed there's no perception in 2007 when our policy was entered into that these clauses were targeted at the Malicious Acts cover. The references to Arnold are in our case at paragraph 68, where we give the references to the 16th and the 17th edition, one in 1997 and one in 2008. My Lords, can I deal, because this moves into really the legal context in which these Institute clauses were drawn up and agreed. The relevant background to the clauses is that 415, as is common ground, was introduced in 1959 into the earlier edition of the Institute clauses. And the suggestion in Arnold is there were, quotes, problems in Indonesian waters, which may or may not have had something to do with smuggling. That's not mentioned in Arnold, but that's the supposition from the insurers. But if that supposition is correct, there is no basis for any supposition that it was intended to address smuggling which was not being done by the owners or the master officers or crew, but was somehow being done by malicious third parties sticking packages on board or on the hull of the vessel. In my submission, the likely surmise, although one doesn't know what was in the mind of the draftsman, was that it was intended to address smuggling in the paradigm examples of smuggling by owners or smuggling by master officers or crew. And it's no answer to that in my submission to say, well, why do you need an exclusion for owners? Because it would probably be willful misconduct anyway, because that's just not the way that the draftsmen of these clauses think. They think to themselves, this is the type of detainment I want to take outside the scope of the cover. My Lords, the relevant background to the 1983 clauses is to be found essentially in one authority on the clauses, which was the ANITA. I accept, of course, that Corrie and Burr is in the background, but Corrie and Burr does not involve any decision on the proper application or construction of this clause or its predecessor. And in our case, we set out the relevant passages in Corrie and Burr, which emphasise that that was a decision which turned on the construction of the FCS warranty as plainly applying to detainments howsoever caused, even if caused by an insured peril. But the anita is clearly something which the draftsman had in mind, and indeed one assumes by substantially replicating the original language in the 1983 clause, the draftsman intended to keep the state of affairs and the decision of the anita very much in play. The anita was a clear case, a blatant case of crew smuggling. My lords, we've given various references in our written case at paragraphs 53 to 55, including the quote from Sir Gordon Wilmer, which is often cited. The common sense of the matter is the vessel will not pay for loss caused by reason of the crew being sick or being caught smuggling. And there's the famous citation of Mr. Michael Mustall, QC, as he then was, which again we set out in our case at 53 to 55, about getting into trouble with customs, which is often cited and was cited by the Court of Appeal. My lords, that's, as I say, 53 to 55. It's page 114 of the appendix. And so the only relevant background from a precedent point of view to this clause is a blatant case of smuggling by the crew. So against that background, we then come to the 1983 revision to the clauses, which we deal with in our written case at 60 to 68. And basically, the draftsmen of the clauses make a number of changes as part and parcel of what my Lord Sumption has already referred to as the revision and the producing two separate sets of clauses rather than simply carving out what was excluded by the FCS warranty. And in 1983, the draftsmen do a number of things. First of all, they expand the scope of the terrorism or malicious acts cover. The comparison, if your lordships want the reference, is to the 1959 clauses which are at tab 12 of the appendix, pages of the appendix is 206 to 207 at tab 12.
That's comparison with?
The 1959 clause.
Yes.
And the 1959 clause on page 206 of the written bundle, 384 of the electric bundle, the insuring clause still has the FCS warranty in it in 1959 in clause 1. But in clause 1.4, the relevant insuring clause is destruction of or damage to the property hereby insured caused by persons acting maliciously. And what happens in 1983, if you contrast that wording with the wording of clause 1.5, is that you now have any terrorist added, any person acting maliciously, or from a political motive, and the opening words of clause 1 make it plain that the insurance covers loss of or damage to the vessel caused by the relevant malicious acts. So in 1959, because clause 1.4 only applied to destruction of or damage to the property insured, the relevant exclusion, which in this wording was clause 4.1b, for arrest, restraint or detainment under quarantine regulations or by reason of infringement of customs regulations, could not have intersected with a claim for destruction of or damage to the property caused by persons acting maliciously, as the Court of Appeal accepted in their judgment. So in 1983, we have the widening of the malicious acts cover. We also have independently, as I've already submitted to your lordships, detainments from barratry now being insured under the hull clauses. The references are clause 6 and clause 23 of the hull clauses in tab 11. Basically, in the hull policy at clause 23, which is page 204 of the appendix 382 of the electric bundle.
Sorry, what was the reference against?
It's tab 11 of the appendix, page 204 in the written bundle, 382 in the electronic bundle. the war exclusion in the hull policy still excludes capture, seizure, arrest, restraint or detainment, barratry and piracy excepted. So going forward from 1983, detainments arising from barratry acts, including barratry acts of smuggling, are now going to be insured under the hull policy subject to due diligence being established, want of due diligence being established. So what we have in 1983, therefore, trying to get into the mind of the draftsman, is a comprehensive terrorist malicious act, political motive acts, into the war cover. And so far as Corrie and Burr and the ANITA are concerned, the draftsman is saying, well, if we look at the universe of cover under the Institute clauses, taking the hull and the war together, you can be insured under the Institute clauses for barratry smuggling, subject to there being no want of due diligence. And the other point, just so your Lordship has this, just so your Lordship have this, so there's no doubt about this, they do apply their minds to clause 415, because the amendments to clause 415, just so your Lordships have this, are they add in trading regulations, which weren't previously there. In the Elisa Glazial, they say that was to do with the consequences of the Iran-Iraq war and widespread sanctions. So one assumes that they had in mind the risk of owners breaching sanctions under trading regulations. The other thing they do in 1983 is they add in clause 415 the words confiscation or expropriation.
Is this whole process a legitimate aid to construction? Because, I mean, it's questionable whether it would be relevant to construe a contract by reference to the various processes of amendment between the same parties. But the fact that the Institute draftsmen have made changes over the years in forms with which the owners in a particular case, and perhaps even the underwriters, may be entirely unfamiliar at the time the contract is taken out. How can that assist? I mean, no owner could be expected either to remember or to carry out research into previous editions of the form.
My Lord, I see the force of that. The point I would make in response is that it is rightly said that these are worldwide clauses. They were introduced in 1983, and they need to be given a business-like interpretation. And what one sees in some of the cases, like for even the clear voulos of Rhodes, where Lord Justice Clark, as he was, says, well, what does customs regulations mean? And one sees the court effectively trying to identify alternative business-like consequences, effectively in the minds of what were the draftsmen of the Institute clauses? These clauses intended for worldwide usage. Were they intended, in that case, to draw a distinction between regulations which related to lawful goods subject to duties or prescribed goods altogether? And the court has, as it were, looked at what the presumed intentions of the parties producing these clauses, these standard clauses,
well, I question whether the intention of the draftsman of the clauses has anything to do with it. It's the intention of the parties agreeing the clauses with nothing more before them but the clauses themselves.
It's not the subjective intentions that matter.
I understand that.
It is what does one discern from a policy on standard clauses as to whether or not smuggling absolutely, as the insurers would say, is intended to be the subject of this exclusion, or, as we say, a more limited class of smuggling based upon the precedent of what had gone before in the ANITA. And if your lordships take the view that it's inappropriate to speculate as to what was going on in the mind of the draftsman, I'm not going to push any further on that. But what one is entitled to say is that one has to look at the overall shape of the cover being provided not just by the war risk clauses, but also by the hull clauses, which is the point that Mr. Justice Hamblin made in paragraph 8 of his judgment. And what we have in 1983, therefore, is a precedent of the ANITA, a very limited precedent of the ANITA, which is deliberate crew smuggling. We have a situation where barracks is now going to be insured under the hull clauses, and on insurers' case, the owners are worse off if the smuggling is done by an independent third party than they are if it's done by the crew. Because if one looks at the universe of cover available, if it's done by a barracks act of the crew, then subject to warranted due diligence, the owners will have cover under the hull clauses. If it's done by a third party, on insurers' cases, they won't. Now, that's not, my lord, perhaps getting into the mind of the draftsman, but looking at perhaps a wider perspective on what's going on here, which is that both in 1983 and in 2007, a ship owner is entitled to say, well, there is cover for barracks smuggling under the Institute clauses, but we say malicious act, terrorist act cover under the war clauses. Mr. Edelman's going to say, no, not so. If the terrorist or malicious actor who's not a member of the crew puts you into trouble with customs, you're ruled out of court. Now, that is the context. And we submit that, insofar as it's relevant, your lordships may say it's not, but there was no sudden mischief in 1983 of malicious acts, smuggling, independent third parties affixing drugs on the hulls of vessel, which somehow warrants treating an exclusion clause which was originally directed at the paradigm case of crew smuggling, see the ANITA, somehow treating that as having a different target. And your lordship may say to me, well, look, it's a question of approaching the clauses, and ultimately it's the width of the terrorist, the malicious acts cover as apparent from the clauses, which in a sense is the point ultimately which matters. But we say, reading them together, we say that the wide interpretation of the clauses, which the insurers contend for, does not derive support from the legal background underpinning the introduction of these clauses in 1983. The lordships may say it doesn't help you, but that's where we are. My lords, that's all I want to say on that. Can I then deal with the question of by reason of causation? And this is partly a question of construction, what does by reason of mean, and partly a question of causation. My submission is that the words by reason of in the exclusion are words of proximate cause. That is the default position in a contract of insurance to reflect the presumed intentions of the parties. The words by reason of are redolent of proximate cause. And to put it colloquially, one shouldn't get hung up by the fact that the draftsman has used different expressions of causation in different places. Because, as going back to Lord Justice Lloyd's point in The Wanderers, not drafted by an equity draftsman. In The Wanderers, two of the members of the Court of Appeal, Lord Justice Norse and Lord Justice McCowan, said, well, it says under quarantine regulations and by reason of infringement of customs regulations. That must be different. And coming from a different background, one can see, well, why one might say that. But Lord Justice Lloyd said, well, that's not the way marine policies are put together. And it's the same with the point, well, this policy says caused by in clause 1, it says arising from in the opening words of 4.1, and now it says by reason of in the salient provision in 4.15. And we say, as Professor Bennett says in paragraph 960 of his textbook, which is in your lordship's bundle, proximate cause doesn't depend on niceties of language in this way. My learned friends say, well, this means it's a double-barreled proximate causation test. Loss arising from and detainment by reason of infringement of customs regulations. But in a case of loss by detainment, as I said to your lordship right at the start, the detainment clause will itself prove the loss, and therefore, in a sense, one's looking at one and only one causation question, which is, was the detainment by reason of the infringement of customs regulations? And we say that in the clear voulos, we've given the reference in paragraph 25 of our case. The Court of Appeal, Lord Justice Clark, dealt with the question of by reason of infringement, as it were, on a proximate cause basis. And we also say that in the Anita, we've given the same references in paragraph 25 of our case. Lords Denning, Fenton Atkinson, and Lord Justice Fenton Atkinson, Sir Gordon Wilmer, dealt with it as a question of causation as well.
But does that mean, in terms of these clauses, then, that it's clear that you can have two, so to speak, concurrent proximate causes? Because, I mean, taking your example of what you say would be covered were it not excluded, namely barratrous smuggling due to the owner's want of due diligence, that would be a detainment, so that's, in a sense, the proximate cause, and covered because the insurance covers loss or damage to the vessel caused by detainment. But then you'd apply 4.1.5 to exclude it because the detainment would be by reason of an infringement of customs regulations, so you get a second proximate cause. The same set of facts, because you're looking at different clauses, gives you two clauses, one relevant in each context.
Well, I obviously accept, my lords, that one has to ask, one has to identify the equation, the two sides of the equation, peril and exclusion, to see whether one has, in an inappropriate case, one or two causes. Clearly, I accept you can have two proximate causes. For example, if we take the example of the Elisa Glacial and the case on 416, there's a failure to provide reasonable security. And the example I gave your lordships earlier, you could have a case where there's a continuing detainment, but reasonable security would have got the vessel free. And at that point, one may say, well, subsequent to when you should have got the vessel to, there are two causes.
Yeah.
But if one rows back to what we're addressing in this case, ultimately I suggest that one's actually trying to characterise, for the purposes of cover or the exclusion, a single cause. Because if I go back to my original introduction, we've got a loss by detainment by an act which was both malicious and an offence. Indeed, it's malicious because it is an offence. Now, on that analysis, the man in the street who's still, we're told, the arbiter of...
Well, it's not presumably an offence at the time when it's committed.
Yes, my lord, it is.
Why is it an offence to stick anything to the bottom of a ship?
It's an offence under Article 31 of the Anti-Drugs Law to conceal drugs on a vessel. And so the answer to your lordship's question is...
That's a customs offence, is it? Where do we find this law?
Sorry, my lord, where do we find...
Where do we find the law, the Article 31, as a matter of interest?
We've given the article, I think it is at the back of the appendix, tab 13,
page 387, my lord.
Right.
Tab 13.
Yes.
And it is page 387 of the electric bundle, 209 of the electronic bundle, 209 of the written bundle. And it is also, I think, in the statement of facts, page 81. So the relevant offence, whoever illicitly conceals, that's the highlighted word, by any means, etc., narcotic drugs will be punished with a prison sentence of between 8 and 10 years. And my lord, Lord Mance's point,
Yeah.
this is the case. I mean, this is an extreme case, and the clear voulos, it's slightly different. But on this case, the very same act of concealing the drugs on the hull is A, malicious, and B, the infringement. And that's what sets up the particular dichotomy on these facts, because the Court of Appeal say there's two causes in this case, one insured and one excluded. We would respectfully submit that the true analysis is that there's one cause, although, of course, one has to see, as a matter of construction, whether it falls within the cover or within the...
But if there's only one cause, and I can see why you say that, why isn't it both insured and excluded? And then you simply have to ask is which, does the exclusion trump the policy clause or the other way around?
Well, my lord, Wayne Tank, which perhaps I'll say a brief word about in a moment, takes me into different territory of the type that your lordship is putting to me, because clearly if there are two causes, one insured and one excluded, then prima facie you have already determined against me that as a matter of construction, and as a matter of causation, either this isn't a relevant infringement, or the loss was not only caused by the malicious act. But that principle depends upon there being two causes. And in answer to my Lord Mance's question, I mean, there may be cases in which, in a particular context, there are two causes. And for example, in Corrie and Burr, where the exclusion clause was held to apply to detainments howsoever caused, including whether caused by barratry or any other insured peril, the dichotomy in that case is clearly between, on Lord Blackburn's analysis, caused by barratry on the one hand, caused by detainment howsoever arising on the other hand. Therefore, to take my Lord Briggs's point, you're looking at two causes, and if Lord Blackburn's analysis is preferred, which nowadays it is, one would say, well, that's Wayne Tank. But the anterior question, going back to your Lordship's point, is this a case of two causes at all?
And it depends for what purpose you're asking the question, doesn't it? If the question is, was the loss here caused by two proximate causes, one may say that it was both the malicious act and the detainment, and that one didn't flow inevitably from the other. That may or may not be right, but that's what's said, and one can see conceptually that there are two competing causes. But for the purposes of 415, as I understand it, we're not looking at what caused the loss, but what caused the detainment. And the cause of the detainment was surely the same malicious act as that which is within the insuring clause.
I agree, with respect. I accept that. That is my case. The cause of if you ask the question as a matter of, we would say under the head of causation, common sense, under more general policy construction considerations, business-like common sense, or however one puts it, what was this detainment by reason of, to use that language? We submit, as a matter of common sense, it was by reason of the malicious act, not by reason of an infringement, which was itself the malicious act. And so, but I'm trying to answer your Lordship's question about there being two causes.
Sorry, why does the fact that it's the same malicious act mean that it's not an infringement? If the malicious act is an infringement, why doesn't the malicious act simply fall within the phrase "or by reason of infringement"?
Well, that is the argument against my submission.
And find out why it's wrong.
Well, my submission to your Lordship in response is that as a matter of construction, in a business-like contextual context, as the judge held, infringement does not mean simply a malicious act which amounts to an infringement. Because if it means simply a malicious act which amounts to an infringement, then you are, for reasons that I don't want to go back over, effectively saying, well, although we'll insure you against any terrorist... So I don't want to repeat the argument, but that's one response in answer to your Lordship's question. The other response, which is under the head of causation, is to say, well, the relevant detainment has to be by reason of, which is words of proximate cause, an infringement, and it's not as a matter of construction or as a matter of common sense directed at a detainment which is by reason of a malicious act which amounts to an infringement.
Well, I mean, I see that as a matter of generality. But when you're applying 415, you actually have to look at the particular facts of the case, don't you? And I can quite see that there may be circumstances in which a malicious act and the infringement are different. But in the present case, you ask yourself, what is the infringement? Well, it's the same, it's the act of attaching the bag of drugs to the bottom of the hull. And you ask yourself, what is the malicious act? And that too was the act of attaching the bag of drugs to the bottom of the hull. So you have got the very same act, which is both an infringement and a malicious act. So why doesn't 415 on that footing apply?
Literally, the insurers are going to say to you, it does, and then the insurers are going to say, well, that means that the claim fails. Because,
And why are they wrong?
well, we say that they're wrong. Your Lordships obviously will have to decide whether I'm right or wrong in these submissions, but we say that they are wrong for two reasons. One, because as a matter of construction of the word infringement, in a business-like sense, it is subject to some form of implied limitation, which does not apply in circumstances where the infringement is simply the malicious act.
got to say the non-malicious infringement.
Yes.
Yes.
Or the infringement which is not the malicious act.
What's the basis of that? I mean, one possible basis is that Hamblin issue 3 is wrongly decided, but that's not the point you're on at the moment.
It's
assuming it was rightly decided.
I'm assuming that it's rightly decided.
Yes.
And I'm saying that one has to ask the question, as in any case, what is the meaning of the word infringement in the sense contemplated by the policy?
But where do you get that from? Where do you get the limitation to non-malicious infringement, especially given the relatively wide way in which you define malice?
I get it, my lord, and this is the submission which you will accept or not, but I get it from a construction of the policy which is not just textual but which is contextual, which is intended to ensure against any terrorist acts, any malicious acts. And therefore, if you have a policy which is intended to ensure against any malicious or terrorist acts, to construe the word infringement literally is to run against a business-like interpretation of a policy which is intended to be comprehensive in effect. And my lord, I can't put the point any further. It's the same argument as to where does one get the word reasonable from, so far as security is concerned, in clause 416. Now, obviously, the considerations are different, but the word reasonable is not in 416. But again, contextually, it makes obvious sense to say, well, that word must be written in. So, well, that's my response to that. But the second response, under the heading of causation, which in a sense comes back to a principle of construction, it comes back to an issue of construction as well, because the two are obviously closely interrelated, is to say that as a matter of common sense and as a matter of construction, where the malicious act and the infringement are the same thing, this is a detainment by reason of a malicious act. It's accepted that that would be the case if this was a put-up job on the Court of Appeal's reasoning, even though technically, legally, under Article 31 of the Anti-Drugs Law, there's still an infringement of customs regulations. I mean, assuming the customs authorities are acting bona fide and so forth.
I mean, the difficulty is you do seem to be trying to split the atom there. Once you've shown me the relevant clause, they seem to be inseparable, infringement and the malicious act in this case.
Well, they are, by the way. That's why the judge formulated his implied limitation as being it must be subject to the implied limitation that it doesn't apply, that's infringement, where the malicious act, where the infringement is simply the manifestation of the malicious act.
Otherwise, it simply takes too much cover away.
Otherwise, it takes too much cover away.
But how much cover is too much cannot be deduced from anything other than the words we've got in front of us.
Well, as I understand,
There's plenty of cover left in 1.5.
there is, my lord, but the effect of this construction is to say that a terrorist who does an act, or a malicious actor who does an act, which doesn't damage the vessel, because clearly picking up that point, malicious damage is still covered, but an act which subjects the vessel to detainment. I'm repeating submissions I've already made in a sense. So but if it subjects it to detainment...
I know, but the last, I mean, 1.5, if one does step back, as you invited us to do, and look at what the drafter might have been thinking about, one might have thought that the last thing he was really thinking about was smuggling. I mean, he was focusing in a different direction, wasn't he? Maybe he's caught it because of the expanded interpretation which has been put on acting maliciously, which may be perfectly correct. But he's not really thinking about detention from smuggling here. Terrorists, persons acting maliciously or from a political motive. He has in mind 1848 and...
My Lord, I would turn it round, but your lordships have had this submission already. When they put the exclusion in 415, they're not thinking about smuggling perpetrated by third parties either.
The exclusion has grown like topsy, hasn't it, though, from 1959. It was really very narrow. then, wasn't it? Or am I wrong about that?
It has grown.
Perhaps it hasn't grown.
It has grown, my lord. It's grown.
It's grown a bit.
It's grown because they have put in trading regulations,
Yes.
and they've put in to keep the symmetry with clause
Confiscation
1.6.
and expropriation.
Confiscation or expropriation.
Yes, I think.
So the target of this clause.
Yeah.
And if your lordship says to me, well, we're not really interested in what was going through the mind of the draftsman, we're only interested in what one can, as it were, glean from, as it were, more objective criteria from the wording itself. What one can say is that clause 415 is directed at arrest, restraint, detainment, confiscation or expropriation, which are the subject of 1.2 and 1.6.
That's the Hamblin.
Now,
Later on, issue 3 point.
there are two relevances to that submission. One is the submission that I have been, in a sense, seeking to develop before your lordships, which is that as a matter of construction, you can give effect to the clause and the Malicious Acts cover but in a business-like construction, the target of the clause, as it would appear to be to an objective view of these clauses, is not intended to intersect with types of terrorist or malicious acts. That's the submission I've been making. The second submission, which is the Mr. Justice Hamblin submission, is that as a matter of construction, the clause is not capable of intersecting with any claim under 1.5 at all. And that's what Mr. Justice Hamblin determined. And in a sense, the two submissions are...
They're really the same submission.
Well, they're not quite the same submission, if I may say so with respect, because all that Mr. Justice Hamblin has decided is that the clause is capable of intersecting, in which case, for the first submission, it's not necessary to have a particularly meaningful intersection, as long as they are capable of intersecting. That actually was what he had to decide in his preliminary issue. I know your lordships look at me and think, well, what on earth's the point of that preliminary issue? But that actually, by the time we got to the hearing before Mr. Justice Hamblin, was all we were arguing about. But the second submission is, well, does the exclusion apply to 1.5 cover at all? And for that, one says, well, if one just approaches it as a matter of language and as a matter of structure of the exclusion read with the peril, then clause 415 doesn't say anything about malicious acts cover at all. It doesn't say anything about terrorist act cover at all. And on that basis, if your lordships are against me on my primary submissions, that from a business-like interpretation of the clause, you can read down the clause but still intersect with the malicious acts cover. If you're against me on that submission, then I do say, on the ground of appeal against Mr. Justice Hamblin's judgment, that the clause does not apply to any claim brought under clause 1.5 at all.
Are you going to develop that a little?
It's in the case.
Shall we, well, while you think about it, perhaps since it's a long morning, perhaps we'll have a 5-minute break.
Of course, I'm sorry, Molly. Yes, you should have stopped me earlier. Of course.
Maybe that's all there is to be said on the point. But,
I'll come back, Lord. Thank you. I'm sorry, Molly. I hadn't realised we were taking a break, so I apologise. I probably should have offered it earlier.
We didn't announce it as we normally do on a long morning, but it's...
Sorry. My lords, I want to say a bit more about causation, but let me just deal with the alternative case on construction, the appeal from Mr. Justice Hamblin. And we set this out in our case at paragraphs 84 to 89. And I mean, it's obvious to your lordships in the way that we've presented this appeal that it's not the primary way that we've been inviting your lordships to approach this. That is obvious.
Nonetheless.
Nonetheless, my lord,
I mean, it raises all sorts of interesting questions. It does raise the question which I raised earlier, whether it's really right to treat 1.5 as covering smuggling at all. That's an alternative analysis. So you ought to get back to argue that 4.1.5 doesn't cover 1.5, but bearing in mind that smuggling falls most obviously within 1.2, why should you be able to circumvent restrictions on which obviously apply to 1.2 by falling within 1.5?
but the answer which underlies all aspects of the submission is that malicious third-party smuggling is not the target of this exclusion. Now, obviously, I've made submissions on the legal context in 1983, which you will or will not find of assistance, and on the settled background to this clause, which is the Anita, which is a crew smuggling case. But it is my submission by one analysis or another that where one is looking at malicious third-party terrorist or malicious actor infringements of either customs regulations or quarantine, the same thing could happen with quarantine, or trading regulations, that the cover is intended to respond, not to respond. And I've made my submissions on what I would submit is the business-like interpretation of infringement.
Can you just help me on how this was dealt with below? I mean, and how it became common ground. There are two possible questions. One is whether malicious includes reckless as to the collateral damage to the ship owner. And the other issue is whether on the facts that recklessness was established. Now, what was the issue, if any, on this? You say that they took some time to reach common ground. Was that because there was a dispute about whether the recklessness extension was right?
Yes.
Or was it a dispute purely on the facts?
As we understood it, the common ground is recorded in paragraph 229 of Mr. Justice Flo's judgment. For your reference, it's page 96 of the appendix. And we understood that the issue was as to whether Mr. Justice Coleman's legal analysis of malice was or was not in issue. And in his closing submissions, Mr. Simon Rainey QC, who appeared for the insurers, made clear that the point was conceded. Now, once that was conceded, there was then no issue that test was satisfied on the facts. Because once recklessness is conceded, I can't remember quite how it went in closing submissions, but it was pretty obvious, and the judge accepted that the perpetrator must have been, at the very least, recklessly indifferent to the consequences on the vessel. So,
is there any other way on the facts that the case could have been put once that proposition of law was conceded?
That's no doubt a question which I'm not sure at the moment.
I mean, obviously one is reluctant, indeed, it'd be quite wrong, to depart from common ground if it might conceivably have affected the way in which the case was argued on the facts. But on what you've told us in the last couple of minutes, this was simply a legal issue. Was Mr. Justice Coleman right or wrong in his recklessness extension?
Yes, I mean, it wasn't argued by the insurers that in the light of that definition, this wasn't recklessness. And the judge at various places, I'm not sure I've got the references to hand, says in terms, well, you can't distinguish between intent and recklessness. 257 to 258 of the judgment, where he basically...
Well, I mean, the argument, I suppose, for limiting malicious would be that terrorists, by definition, are people who are pursuing some cause, generally trying to influence government by illegal action. So they are definitely and similarly people from a political motive, you're looking at the actual motive, then maliciousness might be thought to be doing something similar. But
Yeah, but you see, even terrorists conducting, shall we say, a campaign against a city may not intend any damage to the ship. They may be reckless that there will be, as it were, collateral damage put to the port.
I do submit, it is common ground, that's the first point, but I do submit that the law, in recognising that recklessness rather than spite towards the owners is a sufficient ingredient of malice, has taken a correct turn rather than an incorrect turn.
Well, spite may not be quite the right word.
Well,
if you blow up a cargo ship in order to put pressure on or make a point to the government of the port in question, and spite really may not be quite the right word to sum up what you're doing. If you blow up a warship moored next door and there's a collateral damage caused to a cargo ship, one's instinct is it's still a deliberate act. Recklessness as to the consequences, the collateral damage, if you blow up a warship, may still be relevant. But there has to be an intent to cause damage of some sort. And it may be suggested that an intent to make money by selling drugs in Italy is just not the kind of act which is envisaged.
But I respectfully submit, leaving aside its common ground, my lord, it goes back to, for example, the old case.
Difficulty on common ground, isn't there? Because I mean,
Well, it is, because the litigation has been conducted.
but has that affected the matter factually at all? I mean, it was, as my lord said, it appears to be in common ground by the end of the trial, so it's just a legal agreement. And we ought ultimately to consider what is the correct interpretation, oughtn't we?
Well, my lord, leaving aside cost consequences and everything of that nature, I would obviously need to think about to what extent.
You're not really ready to argue the point.
Well, I would need to think to what extent it might have in any way impacted on matters. But I'd rather address this just confining myself to the substance of the point. If you recall the famous criminal case of Cunningham, which is the person breaks into a house and breaks open a gas meter to steal money, and as I recollect, there's effectively damage to the next door house because of the meter being broken open in one house. Now, one would say about that perpetrator, he had no intention whatsoever to damage or cause injury to anyone in the next door house, which is your lordship's example of doing an act on one ship.
He intended to cause damage. What he didn't necessarily intend was the collateral effect on somebody else's property. And that may be a different kind of category to a case where you don't intend to cause loss or damage to anything at all, but simply to convey your goods to Italy cheaply and discreetly.
Well, I respectfully submit that under a policy of this nature, which covers loss as well as damage, and in the additional insuring clauses which we haven't looked at, accentuates the importance of this cover by reference to malicious mischief and all these other expressions, that it would be wrong to distinguish between the perpetrator who intended to cause physical damage and the perpetrator who does an act either intending on the one hand or recklessly indifferent to a likely loss of the vessel by detainment. And the trouble with this, my lord, I'm trying to A, assist your lordships, but B, invite your lordships to recognise that this is common ground.
More than that, Mr. Chair, this expression, persons acting maliciously, was in the 1959 War Strikes Clause, was it?
It was, my lord,
Looks
yes.
as if it was. Mr. Justice Coleman's decisions, two of them are in 2002 and 2005. Are they foreshadowed by anything to the same effect before? Or was the question not addressed?
I think it's fair to say, my lord, that before Mr. Justice Coleman's decisions, there had been Court of Appeal discussion in the Mandarin Star, as I recollect, in which Lord Denning had suggested that malice required spite.
The Mandarin Star?
I believe it's the Mandarin Star, yes. about 1969, Chioida, it's about 1969.
Well done.
And so this is on my feet, my lord.
Yes, quite.
So Mr. Justice Coleman's decision
Yeah.
applies the criminal law definitions of recklessness-based malice.
Well,
And
yes, yes, all right, yes.
I mean, the
Anyway, it
common-
stood since then. It stood since then. has
it stood since then.
Anybody queried it?
No,
Right.
no.
Right, well, we better allow you to get on with all the submissions,
But-
particularly those you want to make.
I'm always happy to make whatever submissions your lordships want me to make, but that's, I can't say any more about that point for the moment. My lords, coming back to Mr. Justice Hamlin's judgment and the issue which my Lord Sumption raised at the earlier stage, we have set out in our case at paragraphs. Let me just.
84 and following.
Sorry, I just lost it. I'll give it in one moment. 92. Yes, it's paragraphs 84 through to 89, our alternative case on construction. And my lords, if this is the only way in which one can reach a solution whereby malicious acts of smuggling fall outside the exclusion and into the cover, then obviously we urge it upon your lordships. And the basis of this submission is that, as we set out in our written case, the clause 415, as a matter of drafting and as a matter of language, is apparently directed towards the perils set out in 1.2 and 1.6. Simply approaching this as a matter of construction, as a matter of evident language,
Yes.
the clause is not directed
Yeah.
at a loss which the insured can bring within clause 1.5 or indeed 1.4, for example.
Yes, usually the opening words in 4.1.4 and 4.1.5 track very precisely 1.2 and 1.6.
They track them exactly, more or less,
Yes, exactly.
Do we get any assistance from the fact that the first two categories, arrest and restraint in 415, are not included, presumably deliberately, in 414?
Sorry, the
Sorry,
first...
the other way around, isn't it?
No, arrest and restraint.
Arrest and restraint are included in, there's the same list of apparently insured perils,
You're not. Yeah.
but with the addition of arrest and restraint, which are not in 414.
My lord, I suggest that
It's the other way around.
Sorry, yeah.
They are involved.
Capture and seizure.
Sorry, you're quite right. Capture and seizure in 414 are not included in 415.
Capture and seizure would be a rather odd way of describing anything done under customs or trading regulations.
Well, quite. It's not relevant to the facts in this case, but it might be suggested that this emphasises the fact that both 414 and 415 are referring back to the same terms as used in clause 1, but with the difference that capture and seizure are not in perils which the draftsman has wished to include in 415.
My lords, I have to say that there is a danger in this exercise, in going back to an original point I made, in treating these clauses as a coherent whole and basically treating this as if it's the words of a statute.
It can't be impermissible to regard them as coherent.
I'm sorry, my lord?
I can quite see that not all insurance clauses are coherent. The institute clauses are a lot better drafted than some. But you can't proceed on a presumption that coherence wasn't at least regarded as desirable.
My lord, in the specific context in which this case is engaged, I do submit that at least as regards the lack of mention of the malicious acts cover or indeed the strikes, riots, civil commotion perils as well in clause 415, at least to that extent, the draftsman of 415 has indicated that the clauses in 1.4 and 1.5 are not the target of the exclusion. Now, I've already addressed your lordships as to whether that one reaches my preferred construction of all this from a rather wider approach. But at the moment, just addressing the narrower point, which my Lord and Lord Sumption has raised, then if an insured brings itself within clause 1.5, which is the common ground, and we say is in any event correct, in circumstances where someone does a malicious act which exposes the vessel recklessly to the risk of detainment and loss, then on the face of it, having brought oneself within clause 1.5, one has to ask oneself whether that loss has been by reason of infringement of customs or trading regulations. But one also has to ask the anterior question of whether there has been an arrest, restraint, detainment, confiscation or expropriation by reason of the infringement of customs regulations.
Can I just ask this? You referred us to the 17th and 18th edition of Arnold, which support your alternative submission re Hamblin issue 3. When was the edition of Arnold before 2008? The last one before that?
It was produced in three. Volume 1 and Volume 2 came out in 1981.
There was then a complex supplement.
There was the complex supplement, which was 1980.
1961, did you say?
No, so the 16th edition, my lord, was 1981, and that was volumes 1 and 2. That's before the Institute clauses. Volume 3 came out in 1997, after the Institute clauses. And that contained...
Volume 3, which...
And it's Volume 3, which contains the sentence that we relied on. And then the 17th edition came out in 2007, after the clear vouloss of Rhodes. 2008, sorry. And that came out after the clear vouloss of Rhodes. And so the clear vouloss of Rhodes, which didn't argue the malicious acts cover at all, was clearly thought by the editors of Arnold not to change the position.
So every edition of Arnold, after the Institute clauses came out in the form we have here, has had, until the very last one.
Exactly, yes. The 18th edition...
had this statement about clauses 1, 2 and 1.6.
Yes, it said the same thing. The 18th edition, which obviously, I believe it features Mr. Justice Hamblin's decision at first instance, changes the position. My lords, to the answer, well, doesn't that in some way emasculate the exclusion? Because if you can put yourself under the malicious acts cover, doesn't that then strike at the heart of the infringement of customs regulations exclusion? We say, in a sense, for the reasons that we've already developed on our primary case, that's putting it the wrong way, because the exclusion is directed, so far as smuggling is concerned, to the classic paradigm, owner's privity or crew privity, Anita type of case. And so if the effect of this construction is that a malicious act causing the loss is itself...
But it's not necessary at all, you say. I mean, it depends how far you treat the drafters as able to foresee future legal development, but the reality is that you deprive 4.1.5 of almost all its meaning, because you don't need a specific exemption for owner's privity with smuggling, and you need a specific exemption for crew barratrous smuggling. I thought you managed to exclude barratrous smuggling from 1.5. Don't you exclude it from 1.2 as well?
My Lord, just...
Because for the same reason, it's under the Hull policy.
My Lord, we submit, my Lord, that's approaching these clauses the wrong way. I entirely accept...
You've got to see what's left of the 4.1.5. I mean,
well,
they thought they were doing something. They thought they were having nothing to do with customs and trading infringements which led to loss of the vessel.
My Lord, in my submission, the correct approach to this exclusion is not to say, with great respect, what is left with this exclusion clause. It's to ask what was this clause directed at. And the paradigm case of smuggling, which is clearly the essential target of this exclusion, was owners smuggling and crew smuggling. And it's no, my lords, the draftsman did not say, in my respectful submission, we don't need an exclusion for owners smuggling because Section 55 of the Marine Insurance Act is there. They didn't say to themselves in 1983, against the background of the ANITA, well, we don't really need an exclusion for barrature smuggling, because although that was the original purpose of exclusion back in 1959, and the ANITA has vindicated it, now most barrature smuggling will be in the hull policy, and therefore it's only that small case of due diligence that will bring barrature smuggling into the war policy. Therefore, says Mr. Edelman, they must necessarily have been looking at some different target. In my respectful submission, that is the wrong way to approach these clauses. The draftsman of these clauses had in mind a type of detainment which they didn't think read with the perils should fall within the scope of the cover. And against the backdrop of the ANITA, they were addressing the paradigm types of smuggling, not malicious act smuggling. And that is reinforced by the fact that at the very same time, they're giving comprehensive terrorist malicious acts cover. And my primary submission to your lordships is, as you know, that reading the words of the exclusion in a business-like way, in context, you can have an overlap which deals with either interdependent or independent causes where the relevant infringement is not itself the malicious act. If your lordships say, no, we don't accept that submission, then we say, well, the exclusion clause is not sufficiently clearly directed at the malicious acts cover or the terrorist act cover at all, and therefore it is open to the interpretation that not being clearly enough expressed in circumstances where this cover is intended to be directed widely at all types of terrorist or malicious acts cover, it hasn't met the target which insurers say was the target, but in fact was not the target on our interpretation of the exclusion. On the extreme facts of a case like ours, where you do have an act which is both the malicious act and a breach of the customs regulations or a breach of the quarantine regulations, we say that you fall within 1.5 and you do not fall, for whatever reason, within the exclusion in 4.15. And my lord, whichever way we put it, and however you arrive at it, we say that the owners have been the victims of a malicious strategy, a malicious act, and they've suffered loss which falls within the primary insuring clause.
You're effectively reading by reason of infringement as meaning by reason of the ship's infringement, rather than third-party infringement. And that may be a legitimate construction.
Well,
that's the effect of it, isn't it?
It ties in with reading security as reasonable security, my lord. It's the same. It's the same type of implication. Why should a case in which, take an extreme example, suppose the infringement is actually committed by another vessel in the same port, and they nothing to do with this vessel. Why should the exclusion apply? But my lords, I fear I'm repeating the same submission over and over again and coming to the end of my allotted time. But the real submission I'm making is that a malicious act or a terrorist act which happens to involve an infringement of customs regulations is not an infringement within the meaning of the exclusion, either because, as a matter of construction, the exclusion is not directed at such an infringement, or because, and it comes to the same thing, 415 doesn't intersect with 1.5 at all.
Can I just ask you about that last point?
Yes, ma'am.
I think your submission is that the words acting maliciously in 1.5 are shorthand for intent or recklessness as to physical damage or detainment.
They're not exclusively confined to detainment, because obviously you could have malicious acts which involve damage rather than detainment.
Yes, I said damage or detainment.
Forgive me, sorry, Molly, yes.
But once you write out acting maliciously in that way as including recklessness or intent or detainment, does that risk re-attracting 4.1.5 because of the way you interpret acting maliciously? I mean, the first person coming to the clause wouldn't think that terrorists or persons acting maliciously had anything to do with detainment. But once you realise that it does, do you not fall back within within the scope of the detainment part of 4.1.5?
My answer to your Lordship's question, which again goes back to the answers that I fear I may already have given your Lordship in an earlier context, is that where you have a malicious act which intentionally put up job or recklessly causes detainment, then as a matter of construction, business-like construction, in the light of a malicious acts cover which is unaffected by this clause, we would submit, then detainment by reason of infringement of customs regulations does not include a detainment by reason of a malicious act, which of itself amounts to an infringement. Now, I'm conscious I'm coming back, in a sense, to an issue of construction which obviously pervades the whole exclusion clause. And in a sense...
So you fall back on 4.1.5 reference to detainment not being a reference to non-malicious act detainment.
Indeed, I do. Yeah. I mean, ultimately, if your Lordships are against me that clause 415 applies to detainments by reason of infringements even if maliciously caused, or conclude that the detainment is by reason of an infringement even if it's maliciously caused, then in a sense, cadet questia. I mean, that's really the end of it, which is why my submission is that if you take the context, the business-like interpretation in the light of the cover as a whole, with an exclusion which is not expressly directed at malicious acts cover at all, that's too wide an interpretation to put on this language, and it's a wrong interpretation of causation. And my lords, I haven't got time, unfortunately, but in our case, we give examples of general causation. For example, the Etherington case, which the Court of Appeal referred to in their judgment, where exclusion clauses, notwithstanding the apparently wide literal wording of the exclusion, that was the hunting accident, the person falls off his horse, gets wet, rides back, catches pneumonia, dies. Court of Appeal cite that correctly as an illustration of cases where there may be a single proximate cause, even where some supervening event, in this case the wetting and the pneumonia, intrude. Nothing inevitable about that. An exclusion clause which excludes death by disease or injury, even if effectively exacerbated or due to weakness from an accident, is construed as requiring something independent of, something unconnected with, something not a natural sequela of the accident itself. And there's no objection as a matter of causation in saying, well, just because there was a detainment and just because there was an infringement of customs regulations, the real cause, the real reason of the detainment was not the trigger of detection or detainment, but it was the malicious acts that underlie it. And the key to this case is that there was nothing independent or a natural sequela about the detainment due to detection at all. But ultimately, we say that the true construction of this exclusion clause is that, both on our primary case and on our alternative case, that it doesn't cover a detainment which is by reason of a malicious act. And that's a matter of...
Do you agree that we can only actually assess that submission by forming a view about what constitutes a malicious act in this policy? I mean, I know it's common ground, but it's very hard to see how we can assess the submission that you've just made without taking a view about what malice involves,
Well,
whether it's Mr. Justice Coleman's view or not.
well, I can't do more than repeat the references that I've already given you. I'm not in a position to advance that any further, my lord. If your lordships require further assistance on that point, in the event that my learned friend seeks to withdraw the common ground, then obviously we'll do our best to help your lordships. But for the purposes of this appeal, on the basis upon which this appeal's been brought, the appeal to the Court of Appeal was brought,
Yes.
that is my submission. But if your lordships are...
Well, if we feel we need further help, we would certainly ask for it. But it is quite difficult to box a court into a particular view of the law on a point which is of some general importance.
Well, it's a point... the last thing I'll say, my lord, is if the same point could arise in relation to a riot under clause 1.4 where there is no such issue of construction. Take a riot under 1.4. Take the fact that there is no reference in 415 to riot at all. Suppose rioters come on board and they do an act, and my own friend will say, well, this is far-fetched and so forth, but just to test the point, suppose the rioters come on board and set fire to documents which are, on the one hand, ship safety certificates which have nothing to do with customs, and there's detainment. Well, if the detainment lasts long enough, there can be an insured CTL. If the rioters come on board and do an act which happens to destroy documents which are essential for customs clearance, and for whatever reason they can't be replaced quickly, and there's detainment and it lasts 6 months, well, no problems of definition relating to malicious act in relation to riot, exactly the same problem arises. Which is why, in a sense, this is, I know your lordship says in a number of contexts, well, you're not making that much of an inroad into the policy if we accept the owners, the insurer's submissions. But actually, this is a point which applies not just to 1.5, but also to 1.4, and it applies to anything which puts the vessel in breach of quarantine regulations or trading regulations or customs regulations. And you're making big inroads into the insured perils by declining to put limitations on the apparently wide word of the exclusion, or, on the alternative case, if you decline to say that the exclusion doesn't apply to those perils at all. My lord, I've gone over time, and in a sense, I'm obviously trying to assist your lordships, but we've set out in our case more detailed submissions, and I fear that my time is up, my lords, unless there are any specific questions that I can help on.
No, thank you very much, Mr. Schaff. Mr. MacDonald? I have nothing to add. Thank you very much. Yes, Mr. Edelman.
Lords, before addressing the detail of the construction issues, just one point on causation, just to make it clear what our case is, in case there's any confusion. We're not suggesting any break in a chain of causation, as I think might have been suggested to one friend in the course of his submissions. That is a case where obviously there would be a supervening and new intervening cause which overrides the causative potency of what happens before. What we are advancing, and what we advanced before the Court of Appeal, is a case of successive fortuitous causes, the combination of which was necessary to bring about loss, as in Corey and Burr. The first fortuitous cause is, of course, the attachment of the drugs to the hull of the ship. The second fortuitous cause is a combination of the detection of the drugs and the subsequent detainment of the ship for 6 months. Those are successive causes which are necessary to combine in order to cause the loss. And that's how we put our case. So we've never said that, and we still don't say, that if, and to the extent that the attaching of the drugs to the ship falls within clause 1.5, that is not a relevant cause. It's simply that it's not the only cause, but I'll come on to the construction issue in a moment. Obviously, that of itself would not have resulted in the loss.
That's implicit in what I understand to be common ground, that
Yes.
1.5 would answer were it not for 4.1.5.
Yes. I just wanted to make it clear just what our case was to avoid any confusion. And Lord, can I deal with the construction issues first, because we submit that the answer is on construction. There is support in the authorities for what we say is the correct analysis, and I'll come to those authorities.
Which construction point are you dealing with at the moment?
The entire, how the clauses fit together, which is the construction of the clauses. So as I go through, I will deal with the clauses, but one isolating construction points out of the context of the clauses as a whole leads, we say, to the false points that the learned friend has sought to make. And we start off, obviously, with the context. These are internationally used clauses, and so reading words into them is not the appropriate thing to do for their international use, and not what would have been contemplated by the draftsman. We start off under the heading Perils with the introductory words, subject always to the exclusions hereinafter referred to. And we submit that those make it clear that the exclusions are an essential part of the definition of the risk that underwriters are prepared to accept. And it's not just, therefore, a reflection of an approach to construction endorsed in the impact funding case, but an approach to construction which is required by those introductory words, that one treats the exclusions as part of the overall definition of the risk. That they should be so construed, and it's in this respect which I'll touch on the authorities briefly at this stage, has been confirmed in the authorities, and that is the wondrous in the core bundle of authorities at tab 3, page 450. Mr. Justice Hobhouse, as he then was, who said that the clauses include a coherent scheme of the formulation of the risks covered, and to take only one part is not only contrary to the scheme, it's also contrary to the express wording of the clauses themselves.
Sorry, where do we find that?
Lord, this is page 450.
Bottom right-hand.
Bottom right-hand corner.
Yeah. What, the sideline bit?
Yes, Lord. The risks are the perils with the exclusions. Together they delimit the risks covered. Accordingly, defendants are entitled to rely on the relevant parts of Clause 4. And that is the essential starting point. It was confirmed in the Court of Appeal at tab 4, page 459, the bottom right-hand corner. Again, the marked passage. The third reason why Mr. Hallgarton's approach involves an oversimplification turns on a proper appreciation of the way in which the framers of the new institute clauses have set about their task. They've retained familiar capture, seizure, arrest, since in the words of one academic writer, to have tinkered with these hallowed perils would have invited litigation. At the same time, it's important to preserve the essential meaning of the terms in the context of a war risks policy. They refer to political or executive acts. This is the function of clauses 4.1, 5 and 4.1.6. Would I think be a mistake to regard clause 1.2 as defining perils and clause 4.1.5 and 4.1.6 as providing exceptions to liability in specified circumstances. That may be true of clauses 4.2 to 4.4, but it's better to regard 4.1.5 and 4.1.6 as part of the definition of the peril itself. It is the sort of arrest, restraint or detainment which the draftsman had in mind. That is the right approach. I have no doubt failure to obtain normal customs clearance for whatever reason was outside the cover. And finally, in Clearvoulos of Rhodes, Lord Justice Clark, as he then was, this is tab 8, page 516, right at the bottom of the right-hand column. Subparagraph Roman 3, in defining the insured risks under the war risks policy, it's necessary to have regard both to the perils insured and the exclusions, since together they delimit the risk, endorsing what Mr. Justice Hobhouse said. So that is one starting point, supported by the language subject always to the exclusions and by the authorities. And the word always, we say, makes it absolutely plain that the exclusions are intended to apply to all of the insuring clauses without exception. I'll deal later with the point on issue 3 of Mr. Justice Hamlin, but we submit that simply as a matter of the language used, supported with the authorities, that is the inevitable consequence. It's reinforced, whatever the reason may have been for the introduction, but it's reinforced by the fact that when the draftsman did want to qualify the application of an exclusion, this was done explicitly in 4.1.7, where there is a carve-out for cover under clause 1.4. I'm not going to debate the reasons given by my learned friend for that particular carve-out, but its existence, we submit, is significant. If the draftsman had intended any other carve-out, that could have easily been done. Lord, as we say, in our case, any limitation of whatever sort that one tries to read into the exclusions, whether it's by reference to the ambit of their operation or by reference to specific insuring clauses, necessarily involves reading the words subject always as subject sometimes. And that's simply not what it says. And Lords, moving on from those words to the next in sequence, this insurance covers loss of or damage to the vessel. And loss of is the subject of a definition insofar as it's not an actual physical loss, in clause 3. And although the policy that was issued to the owners was one which only required a CTL, a 6-month period for a CTL, one must view these clauses on the premise that the starting point is a 12-month period of detainment. And of course, that's pertinent for some of the rather obscure examples that my learned friend gives of the sort of situations, he says, where there could be a detainment, because one has to bear in mind that one is here contemplating a detainment which will last for at least 12 months in order for there to be a constructive total loss. So one's looking for something that is extraordinarily serious as far as the vessel is concerned. Not the sort of relatively trivial incidents that learned friend included in some of his illustrations. And under clause 3, and this is what of course the owners had to rely on in this case, the vessel has to be the subject of a detainment, and the assured must thereby have lost the free use and disposal of the vessel for the relevant period. And so, in this case, in order to prove a loss, the owners have had to rely on clause 3 and have therefore had to assert that the vessel has been the subject of a detainment, and that they have thereby, as a result of the detainment, caused by the detainment, lost the free use and disposal of the vessel. In our case, for 6 months. Now we return to the introductory words. We're still in the first line, I'm afraid. And we have caused by. And we accept, obviously, that those are words of proximate causation when used in this context. So you have to have as a proximate cause the insured perils. It's now necessary to, my lords, to view these perils in the round, because when one reads through them, they are all what we would submit are typical war risks. The particular issue that's been raised by learned friend in the course of submissions is the ambit of malicious. Lords, I was not counsel instructed for the trial. My introduction came in the Court of Appeal. I would not want to go back on whatever was common ground at the trial, but it is within the confines of that concession open to me to submit this, that when these clauses were introduced, and learned friend has quite rightly accepted, the concept of what was malicious was a very narrow one. It required some spite towards the person at whom the act was directed.
Well, that was Lord Denning's view. Yes. In the Court of Appeal in the Mandarin Star. Was there any other authority for that proposition?
Not as far as I'm aware. And it has certainly, according to Mr. Justice Coleman, been broadened. But if third-party smuggling by something like the attachment of drugs to the hull of a ship or concealment of goods within a ship is within the ambit of malicious conduct contemplated by the clause, what is open to us to submit, despite the concession, is that it's really at the very fringes of the sort of thing that these clauses are contemplating. It's not at the heart of the cover, particularly given taking into account the very narrow focus of what was malicious at the time these clauses were formulated. If it's come in subsequently as a result of judicial intervention. I accept, of course, the parties adopted.
Does it matter whether it's in the middle or at the edges?
Well, it not for my submission, but for my learned friend's submission, it is important.
But I mean, how can we determine this case without analysing what are the facts that bring the matter within the insuring clauses, especially in circumstances where, as both of you accept, the insuring clauses and the exclusions have got to be read together?
Lord, all I'm submitting, the only purpose of my submission is to deal with Mr. Schaff's case that unless somehow one restricts the ambit of operation of clause 4.1.5, it is undermining the cover given by clause 1.5. And my submission is simply that if smuggling, if and to the extent that third-party smuggling is within clause 1.5, it's very much at the outer edges of it. It's not the core part of the cover. If one looks at terrorist, person acting maliciously or from a political motive, and one views those risks in the context of the insuring clauses as a whole and what they're aimed at, traditional war risks, one can see that this is not at the forefront of the sort of war risk that these insurers are covering.
Well, one reason for supposing that 1.5 did not cover, at any rate, smuggling, is that the provision that deals in terms with smuggling, namely 415, on the face of it seems to be addressed to 1.2 and 1.6, if one looks at the way in which the provisions refer back to clause 1. Now, one conclusion that one might draw from that is that the draftsman of 415 did not imagine that customs infringement was within 1.5 at all. He assumed that if it was covered at all, it was only by virtue of the capture, seizure, confiscation, expropriation, etc., covered by 1.2 and 1.6, and that therefore the correct classification of the relevant insured peril in this case was 1.2 or 1.6, which is therefore excluded by 415 because it arose by reason of infringement of customs regulations.
Lord, the other analysis is that with the draftsman having the benefit of knowledge of the established Corey and Burr decision, he would, and as a matter of practical reality, would know that in a smuggling case, the loss is only going to occur if the occurrence of the smuggling is detected, and as a result, something happens to the vessel and it is detained.
Let's go back to the first point, though. I mean, I've just noticed, looking at Mr. Justice Coleman's decision, that it's not just a question of the Mandarin Star, it's also a question of Shell International and Gibbs, were decided by no less an authority than Mr. Justice Mustle, as he had become, in 1981, which was, in its day, one of the most sensational cases, marine insurance cases ever, involving the hijacking of a whole vessel in the days when South Africa was under sanction. I mean, he categorically says that malicious postulates at the least an act of wanton violence directed either at an individual or the goods. And he says it's in the present case, the cargo wasn't lost because the conspirators desired to harm either the goods or their owner. Therefore, it's not malicious. I mean, when you've got that, the committee which drafts these things for the Institute of London Underwriters, or whatever it was at those days, won't have been ignorant of Shell Petroleum and Gibbs. They will have had that absolutely in the forefront to their minds, because it was, as I said, highly sensational case.
Yes.
So, I mean, one wonders whether this point, Mr. Justice Coleman has decided it differently, but one wonders whether it doesn't have some strength. Anyway, it doesn't.
Lord,
You are where you are.
Yeah, I am where I am, and it wasn't. You know, it's something that I've inherited. It's a concession,
Yes.
and it's difficult to go back on it. But the answer
For us to
the,
decide the
yes.
case without having a view on it.
Lord, certainly. I mean, if from our perspective, we would say that all one has to do in this case actually is look at this in context.
Now, I mean, your view is quite simple. You are loyal to the common ground, but you say if you do blow this clause up, then logically you must blow up the exception as well, i.e. expand them.
Yes.
like sausages,
Yes.
to match.
Well,
narrow
Lord,
to match.
Or whichever, yes.
Yeah. The construction exercise and how a loss will inevitably, can only inevitably occur if there's smuggling. The only way a loss can occur with smuggling is the additional fortuity of detection. And the detection will then result in detainment. And then it's a question of whether it's detained for long enough. So, of course, it's possible that there could be smuggling and then something explodes. I accept that. That could be damage to the vessel. But we're dealing with the ordinary case, not the exceptional one that may cause one to find some other solution. But in this case, we then go to the exclusions, and one needs to expect to work through the exclusions as well. And the language of that is 4.1, this insurance excludes loss, damage, liability, or expense arising from. Although it's different from caused by, I accept arising from is again proximately causative language. And one's looking at arising from the identified causes, of which 4.1.4 and 4.1.5 deal with the capture, arrest, detainment perils. Now, they deal with those perils, but they deal with it also as something that happens. Has it arisen, has the loss arisen from a detainment for 415? And that's, again, that is a proximate causation question, but it's simply, at this stage, saying, has it arisen from a detainment? Now, in this case, on our causation analysis, we know that it has. I think that the practical answer to the drug smuggling case, as I said, would be that for there to be a loss, the owner would inevitably have to be relying on Clause 3, a detainment for the given period, and would inevitably, therefore, have to be accepting that a cause of the loss is the detainment of the vessel, the fortuitous detainment of the vessel.
Can you only recover under the policy for a loss which is a total loss?
Well,
The result of detainment. Why can't you, if you're held up for, in your case, 4 months?
No, and then you can't.
You can't.
No, it's got to be a loss of the vessel, a physical loss or a constructive
That's the answer.
total loss.
Clause 3 is effectively deeming there to be a physical loss of
That
the
I
vessel
understand, yeah.
when there hasn't. And so the policy covers for physical loss, physical damage, or the equivalent of the physical loss of the ship, which is treated as being a constructive total loss. So unless the smuggled goods explode and destroy the ship, we are talking about, necessarily about, a loss which is only going to be a constructive total loss. It's an economic loss, which was being referred to earlier, not a physical loss.
Well, it is a physical loss. You've been deprived
Yes.
of your chattel.
Exactly, but it's the loss of, it's not the physical
Well,
damage.
you can be deprived without being deprived
Yes.
physically, in a sense, as all the ships locked up in the
Yes.
Egyptian lakes.
It's not a destruction, but it is a
No,
loss.
Yes, they couldn't get out.
Temporary loss won't do.
But yes, but the fact is that you will get your ship, or you may get your ship back unless it's confiscated.
Well, the insurers will get it back.
Yeah, the insurers will get it if they paid out. Anyway, that's semantic debate. Lord, I'm sorry. Can I just finish this point? I didn't notice the time. My apologies. What one has to then, well, perhaps I leave it there, but one has to then show the proximate cause is the detainment. And then I'll move on to the next stage, which is the under quarantine regulations by reason of after lunch.
we'll look forward to hearing you further at 2. Thank you.